Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
All right, good morning, happy Monday to you. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for being here. We are, I'm scrambling. I'm doing like six things at once. First of all, court is about to begin. I thought it was at 8:30, but now I'm seeing it might be 8:15, and it's 8:15 now. I'm actually a minute late. Hope you had a great weekend, everybody. I hope it was fantastic for you. I have like none of my regular stuff set up, so here's what's going on. Let me tell you really quickly. Let me hide my notes for a second. I promise I'll remember I put them there. Here's what we've got. We've got well, first things first. We have Be Kind Tiger was first in chat. It says my chat was frozen at 7 messages. They all flew by. Not a great start for my interneting. Be Kind Tiger. But rough start. Get it together. The internet is all yours today. Good luck with that. Thank you very much for being first in chat. I appreciate you. You've done this before, though. I think you've won before. If not first offense, it's a great day for success. I think so. Thank you very much. Appreciate you, Be Kind Tiger. Huge stuff. We've got some birthdays we have to sing to. Which so far, let me make sure. I'm watching to make sure the court doesn't begin without me, which I'm not ready for yet. Okay, let's go back here, reset that. Okay, at least, okay, we're good. I can watch that. Okay, right now I'm recording on my slow motion machine back here, this little red light that's glowing. I'm recording, let's see, I think I've got, that's Catherine Beatty's testimony.
I was kicked back, taking it easy.
Her video deposition. Because I need it on the slow motion machine so we can replay it at the appropriate time, because tomorrow after the live stream, after court's over, we have a special program where Dr. G from Dr. G Explains is coming on to talk to us about Sally Smith and Catherine Beatty, and I am so excited about this. I'm like over the moon. So he decided he does want to take a look at this. It's something he thought he was going to push off, and he says, I've got so many people talking to me about this. I want to do this. So tomorrow night, I think it's at 6:30, we have Dr. G Explains coming on live, and we're going to talk about these two testimonies. So I'm recording that in slow motion so we can watch all the reactions in slow motion and replay them. And when he's explaining things, we're going to be able to do that. So I've already got Sally Smith's on there. Of course, that was like this long. Catherine Beatty's is a little longer. I'm a little discombobulated because also I have to get ready to start recording the court out of Colorado. Which we're putting up on the other channel because that starts, eventually this morning as well. And in the meantime, we have to sing happy birthday. Is there anybody other than Crunchy Frog who is celebrating a birthday? I know it was yesterday, Crunchy Frog, but this is as close as I can be. Let's see. I do want to say, okay, court. Man, we've already got a window from court here. Just 1 second. So let's see. We have to listen for this right here. Nope, that's not it. We need on 3. Sorry, sent you guys to black. That's awful. All right, so we've got at least a court feed going, and as soon as there's video, we'll hear that, or audio.
I'm not a
camel. Hear that. Then the other thing we need. Let's hurriedly. I think it's just you. Crunchy Frog. Let's see where it's at. Right here. Here we go. Everyone sing along. It's a rushed birthday song, but we're gonna get it done. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Crunchy Frog. Happy birthday to you. Crunchy Frog, I hope you had a fabulous birthday yesterday, and I hope you get to continue your birthday celebration throughout today. I'm super excited for you to be with us celebrating another 1,000,000 places you could be on your birthday. At 1,000,000 places where people will recognize you for the incredible person you are, including Denny's, where I think they give you free pancakes. But no, you have chosen to be here instead, and to me, that means something. Thank you very much. It's our privilege and pleasure to share this special day with you. All right, that being said, to the birthday music, because court is about to begin. So we've got a couple other things as well. I found a new YouTuber yesterday, the day before yesterday. I think it was Saturday, and I'm liking it. We've got some. Obviously, we've got a lot of people here from Rob from Lawn Lumber, and thank you so much for coming over. I will try to live up to the great praise that Rob gave me. I think he was more generous than I deserve. Just a fantastic lawyer. I've loved his channel for a long time, and thank you so much, Rob. I appreciate that. We also had I was over on Attorney Melanie Little's channel the other day, and I saw a bunch of you over there, and she said some great things about me, I guess yesterday. I heard about it this morning. And so there might be a few of you over here from her channel, and thank you very much. I appreciate that. I love learning from the legal minds of LawTube, really. There are great lawyers out there. I am not one. Let me make that very clear. I am not a lawyer. I'm not a lawyer. Nothing of this is legal advice. I'm a true crime addict, and I love this. And I'm a bit of a tech nerd. Where I shine is getting you the best audio I can, where we can do replays, where we can get multiple feeds going at the same time. So if there are multiple angles available, I can bring those in. That's my area. I'm not LawTube, nor am I trying to replace them. And I love that they do such a good job over there, and I learned so much from them. So thank you, everybody who's coming from those other channels. Wonderful to be with you. Enjoy this. We have a friendly place here that is a lot of fun to be part of, and it's because of this community. Yes, thank you. The sound effects you're hearing are triggered. We have a very interactive chat, at least especially when testimony's not going. We have sound effects and things like what you're hearing here that are triggered by people in chat. Generally for when
Happy birthday, Boo Bear.
Boo Bear? Is Boo Bear? Who's Boo Bear? I don't know. Okay. All right. We're going to turn the sounds down. I ran out of time. I've got more things to say, and I don't have time to say it because I think the judge is coming into the courtroom right now, and I need to figure out how to get an additional video in here. Man, this is getting fun. Okay, so we've got this going on here. Bite Me, thank you very much for that, Rebecca. I appreciate the super chat. Thank you, everyone who came over from Lawn Lumber. We have a very similar community to what Rob does at Lawn Lumber, so you'll probably fit right in. It's basically the same sort of rules apply. You can attack the testimony. We don't attack people. There's no personal attacks. We appreciate divergent opinions in here. We just ask that they're shared respectfully, and we're not trying to beat someone over the head with how we think and feel. So if it gets to the point where it's an argument where you're going back and forth, it gets distracting to everyone else in chat. We ask that you maybe take that to a different platform. And handle that there. But if having disagreeing with me, perfectly acceptable. Odds are I'm probably wrong anyway. I'll admit that up front. But disagreeing with maybe how the polls go, if we do an occasional poll, that's great. That's wonderful. We like that. We like to hear why. Just do it in a respectful way. No name calling. We don't have the salty language a lot of the court cases have. So we'll listen to trial and they'll be dropping F-bombs and everything else. We don't do that here. And I have, if you put those words in chat, YouTube already holds it. It's not the mods ruling it out. YouTube will make sure it just doesn't appear. And we do that just because sometimes some of those expletives that get added in chat, I realize that it's to convey how emotional or powerful you feel about something, but you present it at that level, and the next person reads it and they take it one step further, and sort of chat just can easily spin out of control that way. So that's why we ask you don't do that.
Don't miss the forest for the trees.
All right. I am so far behind on chat. I have not been able to follow what's happened this morning. I'm super excited. This week is going to be amazing. We've got first thing this morning, we've got the judge maybe has a great conversation with both sides, saying, "Hey, what are you arguing over?" Really, because we're halfway through the court, we're beyond halfway through the court case, and the defense still doesn't know what the plaintiff is arguing, and the plaintiff isn't sure exactly what the defense is going to assert, and the judge is like, "You guys need to talk to each other. We shouldn't be this far along and not have a clue why we're in court." So obviously they have a clue. They have all the filings in the original, 8th amended complaint. We'll go over those. I'm looking also at doing a video, I think Thursday night. Might be live, might be tape recorded. I suck at tape recorded videos. I don't know why I can talk live, but I can't talk into a tape recorded, a video camera that's just recording without you there. But we want to go over some things about what got us to where we are in this trial, what point we're at, and where sort of like a catch up for people who joined later in the trial, maybe didn't watch all the way through opening statements, haven't followed this in the news. We're going to be putting something together like that. So Dr. G is tomorrow night at 6:30 on this channel. It will be live. And if my video camera, I might just have to stop this.
Back, taking it easy.
I'm super nervous. You're never going to believe this. With all the cables I have on my desk, I need another. And you can't see them, but there's 15 cables plugged into the back of this machine alone. I need another HDMI cable, and I'm out. I've used everything I own right now, and I need one more HDMI cable, and so I'm going to be on Amazon here in just a bit. But don't tell Miss Sorry. She's like, why do we have another cable? Anyway, we've got fun things happening. Wish we had charts and diagrams, just saying, and a timeline. Red Pen, you ask a lot, but I hear you. This is one of those cases that the amount of content, I'm not talking about YouTube content, I'm talking about different aspects of the case, evidence, witnesses, timelines. The amount of information in here is massive. Is enormous. The medical record alone is more than we could have read had we started at the beginning and continued 24/7 till now. There's so much data in this case to consider, and some is pertinent and some is not. And when you go to the 8th amended complaint, a lot of their allegations have been ruled out, whether it's been in the omnibus ruling or by directed verdict.
Buy me confiscated the credit card, rough paw prince.
Princess Buttercup, it looks like you can't spend money anymore, so bummer. Hopefully you ordered yourself some nice toys while you had it, though. Thank you very much for the super chat. All right, once again, thank you for all our...
Subject matter jurisdiction.
Okay, it is Boo Bear's birthday as well. Boo Bear, I'm sorry I missed that. Can you consider yourself sung to in the birthday song? If we just had it going in the background. Happy birthday, Boo Bear. Wonderful to have you here. We sang to your fellow birthday celebrator already. Sorry, my brain is frazzled this morning. There's so much going on. Boo Bear, have a happy birthday. Thank you so much for being here. Love that you're here today. Hopefully we can make your day special. Thank you. Thanks you. I appreciate that. I'm just running out of time. I should have started like 45 minutes ago, I guess. Anyway, I wanted to say anyone who's coming over from Attorney Melanie Little or Rob from Law and Lumber, thank you so much for coming here. We appreciate the trust that other YouTubers have put in us. And we're going to try to live up to that. So thank you, first of all, for being here. Thanks for giving us a chance. And thanks also to the person who sent you here. Thanks to Rob. Thanks to Melanie. That's huge. That's amazing. And I appreciate that. All right. Here's Judge. Now we're starting. So now I have to mess with the cables. Stop my recording of Beatty. And we'll get it fixed. Oh. Judge working the camera angle. That's on Zoom, so I'm going to check on Zoom right now.
This is case number 2018 CA 5321. Starting with the plaintiffs. Let's take appearances, please.
Good morning. Samantha Lawrence on behalf of the Kowalskis with assistance from Greg Anderson, Nick Whitney, and Jennifer Anderson.
She got it. She got it.
Miss Lawrence, good morning.
Good job, Miss Lawrence.
Howard Hunter, Your Honor, with Pat Crowell's, Ethan Shapiro, and David Hughes, and Chris Altenburn for Johns Hopkins Children's Hospital. Our corporate representative today is Dr. Michelle Smith.
Morning.
She says with assistance from Greg Anderson.
Mr. Hughes is blocking them.
I'm here.
I'm sorry, Your Honor, but preliminary matter, we have, I don't want to ignore the doctor in the room. Dr. Kirkpatrick is here.
The elephant in the room is a doctor.
We have him under subpoena. We left a message with his office on Friday, which he acknowledged he got, that said he did not need to appear this morning. And he's here in the courtroom. And we've advised him we don't need him today. We told him on Friday not to come. But he's here. He's not released from his subpoena, so he can't stay in the courtroom. Not sure why he's here, sir, but I wanted to address the issue.
We want the doctor, just not now.
Is he, I'm trying to figure out where he is in the treating expert panoply of experts.
I think the ruling from the court's been clear that if you're a treater, you don't get to, that the thing's been, that the rule's been invoked. If you're an expert, retained expert, it's not.
I thought the court had made a ruling as to Dr. Kirkpatrick in particular that he was going to be deemed an expert as opposed to a treating physician. But if I'm wrong, I'll tell him.
Well, I think Dr. Kirkpatrick, as a treating physician, needs to be outside. If he were to be here all day for not being called as a witness, I mean, I don't know what's going on there.
We are not calling him as a witness today. We told him that on Friday, his office. We are not releasing him from his subpoena. Depending on where the trial goes and what evidence is in, we may or may not call him.
It's fine, Pat. Doctor, you're going to have to step out. Yeah.
It's like, guys, I'm right here. I can hear you.
I want to begin today, or I guess our next issue today, since we already had a first issue, is to pick up where we were discussing at the end of the day on Friday, which I thought was a very illuminating discussion, but certainly Mr. Anderson and Mr. Hunter weren't in the room. I'm hoping each side has had an opportunity to discuss amongst the individual teams and hopefully with each other the issue that were discussed, i.e. Whether there was going to be a claim for damages associated with Munchausen by proxy from the plaintiffs, and whether the defense had some further statement or clarification as to whether it was contending or not contending that. So, who's going to lead us off in this little discussion?
Since I was on the spot on Friday, I will. We filed last night a memorandum in response. I have a paper copy here for the court.
Is this the one about basically moving to conform the pleadings if we start talking about Munchausen by proxy?
As alternative relief, yes, Your Honor. So
I have read that one.
Okay, well then I'll be succinct. Our position is we are not currently seeking damages for the diagnosis or mere suspicion of Munchausen by proxy. We attempted to do so. That claim was brought for Beata Kowalski in our count 17 for medical malpractice. The defense filed a motion for summary judgment. They prevailed, arguing that they had made no such diagnosis. She was never a patient. Their licensure prevents them from treating or evaluating people older than 22, and that Munchausen by proxy, if it appeared in the records, was a mere suspicion. So for all those reasons, we are not and have not sought damages in this case for Munchausen by proxy. None of our psychiatric experts testified to anything relevant to Munchausen by proxy, the diagnostic criteria, anything of the sort. So we object to the admission of evidence at this point of Munchausen by proxy or documents aimed at shoring up suspicions of Munchausen by proxy. If the defense prevails on this argument, then we do move to reassert count 17 and move forward with a medical malpractice claim for Beata Kowalski.
Ooh.
Please, the court. I'll take these in order if you wish. The first thing I heard was a question of our position with respect to the question of whether there is CRPS here. I'll address that first. Our position is and has been that Maya Kowalski does not have CRPS, that she has a psychogenic disorder of some sort, and that is what we suspected at the time of hospitalization, and that is what we had charted throughout the hospitalization. Throughout the hospitalization, however, we never ruled out CRPS. It cannot be definitively ruled out. As a matter of fact, I'm sure you'll hear one of our experts cross-examine tomorrow with an observation in his report that while he does not believe that she had CRPS, it cannot be definitively ruled out, or at least reasonable minds can differ with respect to that. The point here is, however, and has been, that the treatment rendered for the purported CRPS was inappropriate. That was suspected at the time of hospitalization, and that is our position to this day. The point here is that this patient had a pain syndrome of some sort, and whether it was CRPS or whether she was a victim of Munchausen by proxy and or had conversion disorder or some other psychogenic pain syndrome, the point remains that the treatment for those conditions is the same. The standard of care treatment for those conditions is the same. Whether it's CRPS, a pain syndrome associated with Munchausen's, or conversion disorder, or some derivation of the two or three, the treatment is all the same. That's where we are coming from. That's where we've been. Now, as far as the Munchausen's by proxy is concerned, I would direct Your Honor's attention to what plaintiffs have indicated is the 8th amended complaint. In paragraphs 27 and 28, there is an express allegation that we were remiss in diagnosing Maya with a variety of psychiatric conditions and alleging that none of them were treated. There's also an allegation that with reference to Munchausen by proxy in that same paragraph, and another in paragraph 130. In opening statement, counsel indicated that the plaintiffs were going to prove that the allegations that Beata Kowalski was trying to harm her children, both Kyle and MK, caused her in the end to, quote, lose control of the maternal instinct and resulted in suicide, unquote. There are multiple other references in opening statement to the same type of allegation. The allegation that Beata was wrongfully accused of Munchausen's or of attempting to harm her children or taking inappropriate care of her children goes to the heart of plaintiff's allegations of intentional infliction of emotional distress. The point that is being made throughout here, we think, by the plaintiffs, is that these allegations against the defendant, are the soul of the case. They can't run from that, Your Honor. And preventing us at this point from proving up, as we intend to do today and tomorrow, that Munchausen's was a reasonable suspicion, if not the correct diagnosis, goes to the heart of the defense.
But the diagnosis goes to mom and not to Maya.
That is correct, Your Honor, but it's material to Maya for this reason. Munchausen by proxy may well be, and probably is, an adult diagnosis. It's a diagnosis of the perpetrator. But we have to treat the victim. Maya has Munchausen by proxy. The point is that she's a victim of Munchausen by proxy and or a conversion disorder that is associated with it. That was what was thought at the time. That is what we think today. The question of whether there is a diagnosis of Maya personally, her individually, with Munchausen by proxy is a red herring. The point is that syndrome, we believe there was reasonable cause to suspect and conclude existed, and that it was influencing what was happening and being exhibited in behavior by Maya. That's the point.
And what were the specific allegations in the Eighth Amendment complaint that you referenced?
In paragraph 128, let me make sure I get them all here, Jeff. While Maya, under paragraph 128, while Maya was under its care, JHACH failed to develop a coherent treatment plan for Maya, with its doctors and staff consistently denying Maya's CRPS diagnosis and instead diagnosing Maya with a variety of psychiatric conditions, none of which were treated. Even when advised by pain physicians at other medical institutions that JHACH's approach and diagnosis were inconsistent and mutually exclusive, JHACH failed to correct its approach to Maya's care. In early January, as JHACH was hell-bent on painting Maya as a psychiatric patient while still maintaining to the dependency court that she was a victim of Munchausen by proxy, a physician at Kennedy Krieger grew frustrated with the management team and physicians during a call and advised that, quote, Munchausen and conversion are competing disorders and JHACH needs to pick one. That this did not occur to JHACH as they persisted in their unsound approach is a breach of the highest order. Now that...
I asked what paragraph site. Can you just tell me what paragraph?
I'm sorry, yeah, that's paragraph 128 I just read. Sorry.
Okay, no worries. I just want to know so I can go back and read for myself.
Okay. Sorry.
So just tell me whatever specific allegations that you want me to look at.
And you might also consult paragraph 129 and 130, as well as paragraph 131 and 132. Now that's in the operative Eighth Amendment complaint. If you refer to the opening statement, you will see the passage that I just referred to, as well as a number of others. We did a word search over the weekend of the plaintiffs' transcripts that we have thus far, not all of them. We see 64 references to Munchausen's by proxy in the plaintiff's case. The idea, the central point here, the overarching allegations, as I understand them to be, and as the defense has developed its case, are essentially twofold. Number one, there is an allegation that we failed to appreciate and honor, if you will, a diagnosis of CRPS that this patient had received from essentially 2, if not 3, outpatient physicians. We were alleged to have been negligent in not recognizing that diagnosis, accepting that diagnosis, and continuing the care of that diagnosis as had been outlined by Drs. Kirkpatrick, Cantu, and Hannah, which that we believed to have been destructive and dangerous. But the allegation is that we failed to proceed with treating her in accordance with that diagnosis and that treatment plan. The secondary allegation is that instead of doing that, we suspected a psychogenic component to her presentation. We suspected a psychogenic component to the way in which she was presenting her pain syndrome, as did, by our count, approximately 40 other physicians at 2 other institutions, at Lurie Children's and Tampa General, that we suspected that there was Munchausen's by proxy and or conversion disorder and or factitious disorder, depending upon which of those you subscribe to. And there's a good deal of controversy about them that Your Honor is about to hear a good bit more about. But the point is that the soul of their allegation against us is that we suspected the psychogenic constellation of presentation symptoms, and that was a deviation from the standard of care in the way we pursued that and allegedly failed to properly treat it.
Let me attempt to articulate some thoughts I had that I've been spending over the weekend trying to coalesce. into something hopefully articulable. Assume for the sake of argument, mom had Munchausen or whatever of those terms you wish.
This is the what does it matter argument.
So just assume that to be true. Does that change anything with respect to how the hospital should be treating its patient, who is not the mom, but Maya? And I just as, let me back up. The question of whether mom has Munchausen, to me, sounds like something that would have been front and center in the dependency court on the medical neglect, medical abuse case. In the dependency court, of course, that we're not trying the Chapter 39 aspect in this case. Just like the jury knows that DCF was involved and there was a dependency court, it knows that the position of Johns Hopkins Hospital was that mom had it. But in this lawsuit, do we need to prove whether mom had it or not? And that's what I continue to struggle with, because it doesn't seem to me that it really goes to your medical malpractice case. And I was thinking over the weekend, like, well, does it go to your defense of the intentional infliction of emotional distress count? And obviously, I think the concept that you believed that to be the case, that mom did have it, I think is relevant. But at what point do we need to keep going on and on and on and trying to prove mom has Munchausen? Because even if that's true, how does that change what was done or not done to Maya in this case? Now, I think you've got some traction with me in the intentional infliction count, but what started all this is a whole series of emails and possible blogs about what was going on with Maya that doesn't seem to have anything to do with medical malpractice, but perhaps it does with intentional infliction. That's kind of the dichotomy. So if you'd like to comment on my rumblings there, I'll give you a chance. Because ultimately I need to make decisions on admission of evidence.
I understand, Judge. I'm kind of flabbergasted.
Can I make one comment as the person who understands the DCF part of this?
Well, once I do that, Mr. Altenburn, then I'm opening up.
All the
and
writers,
I was trying to
all
keep
the
us
horses.
more
Here we go.
focused on proceeding forward. Mr. Hunter.
Let me start by noting that based upon Your Honor's rulings, this is not just a medical malpractice case. A lot of it is a medical malpractice case, no question. But it's a battery case, it's a false imprisonment case, it's a negligent infliction of emotional distress case, it's an intentional infliction of emotional distress case. Over and over and over again, we have heard from the plaintiffs this evidence sponsored, that evidence admitted on the basis that it went to the plaintiff's or the decedent's state of mind. The decedent's state of mind is what caused, allegedly, her to commit suicide. Her state of mind was created, allegedly, by what? By her daughter's disease? Probably. But the allegation against us is that we created her state of mind. And we created her state of mind by doing as was suggested in opening, and that is that we were suggesting that her actions and her approach to her child's disease was harming the child. We're accused, that includes we, and there's been confabulation about that. We are accused of separating the child from the mother. Why? Because of the allegation that the mother was doing harm to her child. That allegation is based around Munchausen by proxy. The defense of this case, with all respect, Your Honor, whether it's malpractice, whether it's false imprisonment, whether it's any of these things, all of the defense of this case rests upon the proposition that the pattern and practice of therapeutic and maternal behavior here was dangerous and inappropriate to this child. And that is why reports were made. And that is why suspicions were hatched. And that is why we attempted to act as we did with respect to the discharge of the child or the lack thereof, and the circumstances under which we attempted to treat her and to transfer her elsewhere for more treatment in accordance with the standard of care. But we cannot defend our case, Your Honor, without the idea being a centerpiece that it was reasonable for us to suspect that there was a Munchausen by proxy or a factitious disorder by proxy going on here, and that we were reasonable in suspecting that, and that we were reasonable in acting upon that as we did, and attempting to treat this patient as we did. That is central to the defense of the case. If you emasculate that, you've emasculated our defense. And I don't know what I can tell you beyond that. What you're going to hear today is from a witness who months before we ever saw this patient suspected the same thing. We believe that to be directly relevant to what we did, what we suspected, and how we did it. You're going to hear from our treating physician, Dr. Elliott, one of our employees, about what he encountered, how he responded, what he did. You're going to hear from an expert tomorrow that will pull all of this together, we hope. But I have to tell you, Your Honor, this is inimical and central to what they've alleged against us and to our defense against it.
Let me hear from Mr. White, and I will tell you what I'm hearing about, at least with respect to the intentional infliction of emotional distress count, that there may be some need for some of the evidence that was being discussed on Friday afternoon.
Count 21.
So, Mr. Whitney, let me hear from you, and then we'll move on.
Count 21A.
Well, I'll start there with the intentional infliction of emotional distress. The contours of the hospital's conduct and Ms. Kowalski's conduct, and what was not allowable and what was allowable with respect to her visitation or their supervision, all goes to Chapter 39. So what we've brought forward on intentional infliction are things that have nothing to do with Munchausen by proxy. Catherine Beatty sitting in on phone calls. Catherine Beatty telling Jack to divorce his wife. Catherine Beatty saying that she's going to adopt Maya and be her mother. None of these things have to do with Munchausen by proxy. Listening to Mr. Hunter, the phrases that he uses give away that the Munchausen by proxy is wedded to Chapter 39 proceedings. He talks about justifying the separation. Justifying the separation is what they were doing in the dependency court. And those orders separated the mother and child, but there's no need to justify the separation unless we're going to relitigate the Chapter 39 proceeding. He talks about suspicions. He talks about reports, hotline reports. These all go straight to Chapter 39. Even the allegations he points to in our medical malpractice claim, in paragraph 128, Munchausen and conversion are competing disorders. When we tried to introduce that note out of the risk management file, it was excluded because it was central to Chapter 39. in paragraph 130, the mention of Nurse Ashley stating that Maya exhibited textbook Munchausen. Yes, that's in our claim, but the court's been drawing lines, and one of the lines it's drawn is that the hotline reports are out. Nurse Ashley's characterization as textbook Munchausen is in the first or the second hotline call. That's not part of this case.
I love Mr. Whitney's skill in arguing on his
even if the defense was allowed to put in all of this evidence, they can't close the loop. They have no expert on causation. They have no expert on it. They don't have an adult psychiatrist. They would need an adult psychiatrist. There's no dispute about this. The DSM-5 says the perpetrator received this diagnosis. It's the adult. They would need an adult psychiatrist to come in here to close the loop. The context of 64 references to Munchausen by proxy in our case. There's no specific citation, and I did not review the transcripts that they have. But the court will call the Munchausen by proxy term is what was thrown around in that transfer diagnosis to Nemours in the midst of the dependency proceeding. So I'm willing to wager that 95% plus of those references to Munchausen by proxy are specific discussions around that transfer diagnosis and the reasons that Jack and Beata declined transfer under those circumstances. Nothing about our experts getting on the stand and making arguments or opinions about whether Munchausen by proxy was or was not the appropriate diagnosis. And lastly, on the psychogenic constellation of Maya Kowalski. The psychogenic constellation of diagnoses of Maya Kowalski does not include Munchausen by proxy. It cannot. The psychogenic constellation of Maya Kowalski has to do with what their psychologist diagnosed, Dr. Katzenstein, who I think we hear from today, psychological factors affecting other medical conditions. That's the DSM-5 diagnosis of Maya Kowalski, confirming that she has CRPS, but she has a psychogenic overlay on that. The other diagnoses they entertained for Maya Kowalski in this psychogenic constellation are factitious disorder, not factitious disorder imposed on another, but factitious disorder of Maya Kowalski and conversion disorder. So there are at least 3 diagnoses of Maya Kowalski that they threw around that compose this psychogenic constellation. None of them are Munchausen by proxy. They go specifically to Beata. So again, if Mr. Hunter's argument persuades this court, we move to reassert count 17, because now they're claiming they did make a diagnosis of Munchausen by proxy. They want to argue all about it, and so we want Beata Kowalski's medical malpractice claim back.
And that was gone a long time ago.
Are there other issues, because it's getting close to 9 o'clock, other issues that we have to address before we bring in this jury?
I don't believe so, Judge. I just point out that as counsel just made reference to, an inimical point of the false imprisonment claim is the fact that there was a transfer offered, there was a transfer that was put together, you're going to hear more about it tomorrow morning, and it was refused. Why was it refused? Because of that diagnosis. Because of the diagnosis. Because, to almost directly quote, we would be admitting to Munchausen by proxy to child abuse if we signed off on those transfer papers. They put this in the case from day one, Judge, and they can't run from it now.
But okay, how does you proving that Maya did or did not have it change Beata's state of mind as to her decision not to sign the transfers concerning or when there was any sort of possible reference? And I think, though, that came later as opposed to the October date.
Yes, correct.
So, let's try not to conflate those. I'm having enough trouble keeping those two apart in my mind myself. But, I feel like I've clipped the plaintiff's wings very hard on trying to keep Chapter 39 out. And it just seems that now that I've done that, the defense wants to make this case in trying to prove that Beata had Munchausen, which seems to be the heart of what was going to be in the dependency court, which is what I was not letting in. in the plaintiff's case in chief.
With all respect, Your Honor, you have ruled on the Chapter 39, and to be honest with you, I have yet to understand where the dividing line is on this. But what I do know is this. What I do know is that the remaining case against us, whether it's the false imprisonment or the intentional infliction or the negligent infliction of the malpractice, is all bound up in what we suspected and what we did and how we ruled on it, and the impact of that on Mrs. Kowalski's state of mind and on her conduct. And that's, I mean, if Your Honor tries to carve that out of this case, it eviscerates a major portion of the defense and puts us in a completely untenable position. I would suggest to the court that Mr. Whitney's argument is for the jury. It's not for admissibility. And I would urge Your Honor to let this go forward and let us try our case.
Are there other issues that we have to address prior to the jury coming in?
Well, Judge, the first witness is on this issue.
On Beata's, whether she has?
No, Judge, the first witness is Dr. Elvin Mendez of Fort Myers. Dr. Mendez saw this patient in October of 2015. In December of 2015, he was consulted regarding immunotherapy, and after 2 visits with this patient, he indicated in one of his conclusions that Munchausen by proxy should be considered, and he advised Dr. Wasenauer of that fact in a copy of a letter to him. The point of his testimony is exactly this, and the point of his testimony is, frankly, a point I thought I tried to make an opening, and that is that we stumbled upon this trail and followed it. It was not a new trail.
Mr. Altenberg.
2 completely unrelated things. I'm only here for a little while, hopefully, to find out, A, if you've looked at the instruction that you're contemplating on the visitation at all, because Mr. Elliott and I need to kind of get closure on that, because by Wednesday we really need to have had that instruction read. The other thing I was waiting to see was how many counts were going to be gone or not on directed verdict, so I can finish the jury instructions.
Well, I don't have time to address that right now. Hopefully, after lunch, we can close the loop on some or all of the DV motions. So I don't know if you want to hang out until after lunch to see.
I've got a room I can type in all morning logs.
And Mr. Whitney, anything else?
Well, 2 things. On Beata's state of mind and the relevance, the state of mind of Beata Kowalski that's at issue in this case is the irresistible impulse, effectively. And I would point the court back to their motion for summary judgment, again on count 17 at DIN 1933, in which they made a big point of pointing out that she was admitted to Sarasota Memorial Hospital the day of the dependency proceeding when she fainted in court, and that at that time she denied ideation, and that as of that date she did not have ideation. So her state of mind deteriorated over those next 3 months, irrelevant and irrespective of what Dr. Mendez may have thought in October of 2015. I think we need to argue this Dr. Mendez issue.
Well, I think with Dr. Mendez, I'm going to be consistent with what I did with the prior treaters that saw Maya prior to the admission to Johns Hopkins Children's Hospital, and kind of let that type of testimony in, because it does set the stage as to how Maya presented at Johns Hopkins Children's Hospital in October of 2016. So I think the historical stuff, at least I'm going to continue to rule like I did with Lurie's doctor and the Tampa General Hospital doctor. I'm just going to stay consistent. If I'm going to change how I'm doing something, I'll let you know. But for now, I'm going to remain consistent as to how I ruled with respect to those 2 hospital visits.
May I make a record on that?
Sure.
Well, we believe, again, this is Chapter 39, issue 403, and irrelevant to the claims in this case. I'll point out again, at the time Maya Kowalski was hospitalized at Johns Hopkins Hospital during the false imprisonment first week, they did not have any knowledge of Dr. Mendez's records.
I don't think it's going to false imprisonment. I mean, I know it's been banning about, but I don't see how it goes to false imprisonment. I am, frankly, the only place it really seems that it possibly fits is the intentional infliction count. I still don't understand how it would fit with medical malpractice with respect to Maya.
Right.
But I mean, I do think, and I do have some belief it does go to the defense of your IIED count.
Understood. We disagree, but we understand.
Okay. So are we ready to bring in the jury?
Preserve the record.
Let's bring in the jury.
All right, jury's coming in. All three Kowalskis are in court. Spicy argument this morning. It sounds like we've got possibly some DV rulings coming in that we're waiting on from the judge at lunchtime. We're going to have some testimony from people. This is going to really, it sounds like, make Beata look very bad.
Jurors entering.
This is anyway. It's going to be a very interesting day in court. I'm gonna swap views. Just 1 second. We're going to go right here. So it's going to back out just a tiny bit.
All rise. Jurors entering.
There we go.
Okay, welcome everybody.
This allows me to sync up.
How are we doing on a Monday morning?
There's a dropout.
Great. Glad to hear it. And we're the best birthday festivities fun? Yes.
Sorry, we're going to back up just a second.
Okay, welcome everybody. How are we doing on a Monday morning? Great. Glad to hear it. And we're the best birthday festivities fun? Yes. I want to confirm, while you were away over the weekend, you did not discuss this case amongst yourselves. You did no investigation, and you received no information. Is that all correct? Correct. And since you were last with us, has anyone seen any news accounts of this proceeding? And has anyone approached you about this case since we were last together? Mr. Hunter, your next witness, please.
Okay, please go with the honor of the defense calls Dr. Elvin Mendez.
Dr. Elvin Mendez, this is the doctor that saw Maya in 2013 and might have some things to say about his suspicions about Beata, is what that's sort of what's been telegraphed to us so far.
Mr. Clark, can raise your hand?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do. Right this way, sir.
Good morning.
Good morning.
Would you tell us your name, please?
Elvin Mendez.
And what is your occupation, Doc?
I'm currently a physician with Lee Health in Lee County and Charlotte County.
Okay. And where is your practice?
We have two locations, one in the Port Charlotte area and a second in Cape Coral.
Okay. And what is your specialty, sir?
Allergy immunology.
Would you give the jury the benefit of your background and training and education starting with undergraduate school?
I trained as what they call a foreign medical graduate, so we do undergrad and med school in one 7.5-year stretch. So this was done in the Dominican Republic. I came to the U.S., trained in pediatrics in Long Island, and then moved on to Einstein and did allergy immunology. After that, I joined private practice for 4 years, joined a non-for-profit for another 4, and then we headed south to Fort Myers. We've been in Fort Myers now, Charlotte County for about 21 years now, and joined Lee Health in 2015.
Okay. And I'm sorry, Dr. Amos, where did you do your residency?
In Albert Einstein College of Medicine, New York.
In New York City?
Yes, sir.
Okay.
I'm sorry, that was my fellowship. My residency was done at NASA University Medical Center in Long Island, New York.
So you did both your residency and your fellowship training in New York?
New York, yes.
Okay, Greater New York. And what are you board certified in, sir?
I was board certified in both allergy, immunology, and pediatrics. After years of allergy, immunology, I decided to give up my board certification in pediatrics. For no particular reason, I just continued doing allergy, immunology through the last 20 years.
Okay. And could you tell us what allergy and immunology entails?
Okay, so from an allergy standpoint, it's we deal with a variety of different organ systems that have an allergic or immune mechanism involved. So, for example, make it easier, head to toe, sinus disease, nasal symptoms, sneezing, congestion. That's the one that we see most commonly in the offices. We also deal with skin disorders, but they have to be specific allergic skin disorders. From the lower airways, in other words, further down, then we deal with asthma and asthma-like symptoms. There are some occupational lung diseases that we may deal with when they're exposed to certain chemicals, and certainly there are other organs that are involved specifically with allergy, for example, GI or gastrointestinal system. There's a variety of not only food allergies, but also diseases that are associated with that. That's the bulk of the allergic side. The immunologic side is a little more complex. There are mechanisms that we deal with that encompass both the allergic and immune world. It's not just immune deficiencies. There are a lot of overlaps with rheumatology, so there's some autoimmunity that we may deal with. Certainly, it gets to a point where we then end up referring to rheumatology. So immunologically, it's predominantly immune deficiencies that we deal with in pediatric and adults. Bless you, sir. And from a allergic standpoint, there's often an overlap between one and the other, because some individuals with immune problems may present with what appear to be allergic problems. Okay. But it's one same field.
Okay. And does it also deal with immunodeficiencies?
Yes, sir.
Okay. Has there come a point in your practice with Lee Memorial Health System that you became involved with the care of Maya Kowalski?
Yes, sir.
Okay. And when did that take place, sir?
I saw her twice. The first time was in October 28th, 2015.
Okay. And do you have your notes with you, sir?
It's in my head. Yes.
Okay.
Yes, sir.
Okay. Well, if for the record, that is Defense Exhibit 3031, and it starts with 002. So if you want to put that up, I believe that's in evidence. And if you need to refer to that to your records, if you'll let us know, we can scroll down through.
Absolutely.
But for now, could you tell the jury how it was that the Kowalskis came to see you in your practice?
The original visit on the schedule was for a second opinion for immune deficiency.
Okay.
Do you want me to dwell on that, or?
Yes, sir.
Okay. So this is my. Just looking for a date here because we saw her twice. So this was our first visit, and there was a different reason for the second visit, and we'll get to that later, I'm assuming. But for the first visit, it was on schedule as a second opinion for immunodeficiency.
Okay. And what was your understanding of where the patient had already been with respect to immune deficiency questions?
I'm sorry, could you elaborate on that question more specific?
Well, you were asked for a second opinion, and I'm trying to find out who the first opinion was, I guess.
So when you call our offices, we're going to want to know why you want to see us. Someone offered that information to our staff. That's all that was on our schedule. It actually says second opinion for immunodeficiency.
Okay.
The idea is that they're coming to see me because they are perceiving they may have a problem with immunity.
Okay. So did you take a history from this patient, and was she accompanied by her mother?
I'm sorry, was
she accompanied by her mother?
Yes, just her and her mother, yes.
Okay. And did you take a history from her?
Yes, sir.
Okay, and what did you find out from the history?
Overall?
Yes.
Complex. There were a lot of things going on.
Okay. Generally speaking, what history did you get from them?
You want me to be specific, sir?
Yes, sir.
Okay, so we cover quite a bit. Just because someone comes in with a concern about immunodeficiency, there's a lot of questions I ask because, like I said earlier, immunology and allergy do kind of overlap. So you'll see in the notes, or perhaps I don't know if it's been discussed before, that there are questions that don't seem to even correlate with what they originally came in for, but there are reasons why we do that. So to answer your question, we covered quite a bit of organ systems, so that's a review system we do and we cover, and if there's anything striking within that review system, we will dwell on that particular problem. So she did all the talking. She was a great historian, I gotta say. She was very bright. So it was easy. I hate to tell you, in immunology, it's not an easy thing, but she was really good. So I was able to obtain the history on her part with regards to, because I did ask why a second opinion, and she said she wanted information on her daughter's immunodeficiency. Unfortunately, I had nothing at the time, just her history. So I had to request records.
And did you conduct an examination of the patient that day?
Yes, sir.
And what did you find, if anything?
So two things. The first thing that was striking was that she appeared to be in pain and a lot of discomfort. She was wheelchair bound, by the way, in my office. And I remember her very well because she was sitting literally next to me, and the mother was just facing me here. And she appeared to be in pain. And the only way I can say this is because she was kind of moving around on the wheelchair, and some sounds were made as if she's in pain. So, but I was able to examine her. I did not elicit additional pain. I do recall that because I'm very cautious about pain. But I did not perceive, or rather induce, any additional discomfort during the examination.
Okay. Did you find out in the course of all this what other immunologists or allergists she had seen?
Yes. So at some point during the history taking, it appeared that she had already seen actually 2 additional allergists.
Okay. And did you get any understanding of why it was or how it was she had come to see you?
No, sir. Her answer to me, and again, this is recollection from my notes, not recollections that because this was about 8 years ago, was that she was just seeking an answer to her daughter's immunodeficiency.
Okay. So at the end, well, did your examination include an examination of the skin?
Yes, sir.
Did you find anything unusual or untoward?
No, sir. That I can recollect, no.
Okay. And what, at the end of your first consultation with this patient in October of 2015, what was your plan? What was the follow-up, if anything?
Several things. Because there was a lot. It wasn't just immune concerns, so obviously I needed those records from the other allergists she had seen before. There was also so when we look at an immune deficiency, we want to determine if we can figure out what the cause is. You know, is this something that she's had since she was born? Is this something that she has acquired since she was born? So we need to inquire about things that may induce what we call a secondary immune deficiency. So other medications that she's been on. So we requested records from other physicians that had seen her at the time. So I have a sense of whether this was induced by other things that may have been given to her. What was striking in her history is that she had been through numerous ER visits, numerous physician visits, and a lot of steroids. And that's, to an immunologist, that's striking because steroids are a double-edged sword. They solve a lot of problems, but they also can induce a lot of problems. So I wanted to make sure that this wasn't secondary to medications. So to answer your question, it wasn't just focusing on immunity and getting records from the allergies she had seen in the past, but also perhaps some of the other areas that she had visited that may provide me some information and some insight, especially in lab work.
Okay. Now, when you took a history from this patient, did you get any indication that she had been in Tampa General Hospital for about 4 weeks?
No, sir.
Did you get any indication that she had been seen and worked up at Lurie Children's Hospital in Chicago?
So that's a tough question. So yes, and we're referring to prior to moving to the state of Florida or after?
After.
No, I was not aware of that.
When did you see this patient in follow-up?
It was the second week of December of 2015. Actually, it was on her birthday.
Okay. And I believe that's Defense
December 10th.
3031-007. Not the James Bond, but the page number. If you need to look at your note, Doctor, I believe you'll see it there.
Yeah. Mm-hmm. Okay.
When you saw her in follow-up in December, what additional history did you get at that time?
So the first part of that page just gives you kind of a summary. I tend to do that for providers that might want access to the notes. So it kind of just summarizes what has transpired in the initial visit, and then I move on to anything that's new since we've last seen them. At that point, we did have records received because we had requested several, and I believe it was at that time that I may have received notice between the first allergist she saw and the second visit to the first allergist, which was Dr. Wyndham. There was a lot that went on in that period of time. And someone wrote a note that she had been to Lori Children's for another opinion. I think it had to do with her cortisol level. So there was some concern that there may have been adrenal suppression. When you go on high-dose steroids for extended periods of time, you will literally suppress your adrenal gland. Your natural cortisol is produced by an organ within your gut cavity. The brain sends signals to that cavity, to that organ, to tell it produce more, produce less. But if you give it outside long enough, it'll stop sending that signal. The problem with that is if you stop administering that steroid, you'll go into adrenal shock. So it's a dangerous situation to be in. So I'm assuming that they were seeking a second opinion at Lori Children's because that was the hospital when she was a child and growing up in Chicago. But I'm not sure if that was true. I don't have any records of that.
Okay, so you never saw any records from Lori Children's?
Just mentioned on one of the notes.
And you were never told what the discharge diagnosis from Lori Children's was?
No, sir.
And I'm assuming you were never told what the discharge diagnosis from Tampa General was?
From
Tampa General.
I wasn't aware of the Tampa General. I'm sorry, let me correct myself. All I heard was that she had undergone rehabilitation at Tampa General.
Okay, and were you aware of the discharge diagnosis?
No, sir. I just was told there was rehabilitation at Tampa General, and it had something to do with her cortisol level.
Okay. When you saw her on this day in follow-up, did you do an examination at that time?
Yes, sir.
And what did your examination reveal?
Completely normal physical examination.
Okay. Did you note any color changes or rashes on the skin?
No, sir.
And did you get any history of any episodes of dizziness or weakness or lightheadedness with the patient?
The second visit, I don't recall that coming up as a part of the history. The first, there was a persistent headache throughout the visit, in the first visit, and I believe there was also dizziness described.
Okay. Now,
this guy's memory is incredible.
After you had conducted your examination and your history and physical, and you looked at some records, I'm assuming, from her past care, did you arrive at any opinions or conclusions regarding her immune status?
First or second visit?
Second visit.
Okay. Yes, sir.
And what was that?
That she... May I explain?
Yes, sir. Yeah, you're the only one who can.
Okay. So...
Objection, narrative response.
There are numbers that we follow in any lab work that you have done. I'm sure some of us have had those done, and there are some values that are considered above normal or below normal. And the lab does that. It gives you a certain range. So if you go to one lab, you're going to get one range. You go to another lab, you get another range. And typically, we follow that as a tool. It helps guide us to determine whether there's a problem with your liver, spleen, or an immune problem. With immune deficiencies, there are international standards that we follow or try to follow. There are also some national standards that we follow. The numbers, when you look at a lab, may appear to be grossly abnormal. Okay, so you'll have I'm just going to make a number up for y'all folks. Let's say, the normal for a 9-year-old of an immunoglobulin G should be, according to the lab, 600 to 1200. That's what they'll put on as a normal. 600, low, 1200. Now she's at 550. Is that considered abnormal? Okay, so that's the question that you ask the immunologist. My short answer is it's not abnormal. And the reason for that is because there's very specific criteria that we have to follow to determine whether an individual has a deficiency or not. And if I may, just briefly to the jury.
And while you're doing that, I'm going to ask that 3031-009 be put up. That's where your lab values are, in case you need to refer to those.
Okay, so
down at the bottom.
Right, I see that. Okay, so I want you to see that there were two numbers that were given to us. And the reason two numbers during the same lab draw are different is lab. So one lab, the same lab did the total IgG, the immunoglobulin G, the total, and then something called subclasses. So total IgG is broken down into 4 components. And they're numbered 1, 2, 3, 4. Okay, so one set of numbers gives you a low total with a low IgG 1 and 2. That was the subclasses that were done. On the other hand, the doctor also ordered separately a total IgG. Now we have 2 discrepant numbers. One same draw, same person. So we have a 575 on one number, and we have a 603. I see those numbers and they're staggering because there's a significant difference between one and the other. One of them appears to be not grossly abnormal, but just decreased, and the other one appears normal. So just for the record, these 2 numbers are normal for an immunologist. But so criteria number 1 is you take that, you measure that value. You want that immunoglobulin G. Yes, you can order the subclass because oftentimes one of them will drag the total down, right? Because the top is the sum of all the little ones. But the general consensus, and these are International Immunology Society regulated rules.
Sustained.
They have to repeat it again.
Hold on a second. Let Mr. Hunter ask another question.
You can't make reference to outside sources.
I'm sorry. Apologize.
So if you just tell the jury what these labs meant based on your experience and training.
Sure. So based on my experience, a single digit is just a reason for me to wait, based on current standards, a minimum of 2 to 3 months and repeat them again. Because standards are, there has to be a minimum of 2 separate draws with a minimum of 2 to 3 months between each. But that's just one of 3 criteria.
Okay. So at the close of all this, and your second visit with this patient, and the labs and records and so forth that you had the opportunity to review, did you arrive at any opinion or conclusion that you were able to share with the patient and her mother regarding whether or not she had an immunodeficiency?
I was, yes, sir.
And what was that opinion?
My opinion was that either Maya had something we call transient hypogammaglobulinemia of infancy and childhood, which is a transient type of deficiency we see, and it normalizes over time, or that she did not. Personally, with a normal immune response to the vaccines that she had and the rest of her lab work, to me, she was normal. She had no other immunodeficiencies. Typically, you have other immunoglobulins that are reduced. You don't have an adequate vaccine response. Those are the other 2 criteria that are required for you to be diagnosed as a immune deficient. So I explained this to her at that visit.
And to state that a different way, was there did you determine that she had any immunodeficiency that required follow-up treatment?
No, sir.
Okay. Did you arrive at any other opinions or conclusions regarding her condition and matters that should be addressed in her care?
Yes, sir.
And what were those?
Okay, so the first is, we'll start from Morgan Systems. The first is this asthma history. We deal with asthma. That's part of our training as well. We rely on tools to help us. make a determination whether someone has a disease or not. We do that with every disease. The reason why we rely on tools is because we have to have not only the history provided by a parent or a child, but also we need to have some objective measures. You have to always have something to help you guide you and determine whether there's a disease there, because there's a lot of mimickers of asthma, lots of them, and nothing added up here. Pulmonary function tests were normal. I was only, unfortunately, able to see one, that Dr. Kreisman, who's a pulmonologist, or I'm not sure if he's still at All Children's, put on in the records. And there's also mentions of normal pulmonary function testing throughout the visits. So from a respiratory standpoint, unfortunately, I could not make an intelligent decision that she actually had asthma. That's the first thing. With regards to the allergies, yes, Maya had allergies based on skin testing performed by an allergist, but to me that was secondary. At the time, I think we were dealing with much bigger medical problems that I think needed to prioritize over allergies.
Okay.
And then the last item, with the concern about the chronic the CRSP, is that I'm not a neurologist. She talked about RSD. She talked about a lot of problems, neurological problems that might be wrong with Maya. I specifically told her that was way outside of my wheelhouse and I'm out of my lane, and I'm not an expert on that. And she'd have to talk to her primary care or neurologist about that.
Okay. Were you aware that her primary physician was Dr. Wasnauer?
So I only was aware of Dr. Wasnauer because his name comes up. Our records, we provide all primary doctors with notes. Whether you refer them to us or not, as a courtesy, every primary doc gets a letter. Sometimes the patients will not provide us that name, so it's just left blank. But as a general rule, they do give us the name, and we provide them with a letter. So that's the only knowledge I have of him, because he did get my letters. We did request records from him and never received.
Okay. And did you send him any information about your consultations with this patient?
Every visit, yes. And in our assessment, yes.
Were there any other considerations that you called to his attention?
Yes, sir.
And what was that?
So physicians are trained to be alert on anything that might be of, should we say, harm to a child.
Here it comes.
Right? Any risk, any concerns that may come up during a visit. It could be a variety of different things. The one item that was of concern at the time because of some events, some things that I saw during the office visit with her, from my reading of the documents I received prior to her second visit, I can only use the word did not add up. And so my concern was that this might be fictitious and not true events that were occurring. Either way, I wanted the primary doctor to dwell further and see if there is a neurological problem with her or not. I was basically telling him, hey, you need to find out if this is true or not, because this is harmful for her. She's wheelchair bound. She's in pain in my office, and that's the last I've heard of the Kozlowskis.
And so what specifically did you call to Dr. Wasnauer's attention in that regard?
I'm sorry?
What specifically did you call to Dr. Wasauer's attention in that regard?
So I was concerned about Munchausen by proxy at the time.
Okay, and why was that?
Because the symptoms, the physical examination, the objective tests that I've reviewed in medical records did not correlate with the story I was getting from home.
In what respect? Can you be more specific?
So there was a constant. The first is the numerous lower respiratory complaints, the asthma picture, the severe asthma. And that was used a lot in a lot of the notes. Severe asthma, severe asthma, severe asthma. Like I said, in my experience, we have someone with severe asthma admitted to a hospital for a few days and comes out with normal breathing tests, completely normal spirometry. The lung doesn't work that way. I'm just being honest with you. When you get to a severe case, there are maybe some changes that take place within lung tissue. Your lungs will start over time sort of scarring within the bronchial tubes. That's why individuals that are not treated early on adequately will get worse over time. you can improve their ability to breathe with medications, but the breathing test was always going to show you some degree of changes in the lungs. There's always going to be there. I looked at the PFTs, the doctor from Old Children's, Dr. Kreisman, provided in his notes, and they were completely normal. So, and that was just one event. There were other severe asthma, and the most striking and most concerning was the numerous steroids utilized, both inhaled, oral, and in injectable forms in various ER visits, clinic visits, provider. And in fact, she actually had access to, I believe, to steroids at home that she could provide her.
Motion strike.
The objection motion to strike had to do with that the fact that she had injectable medication available to her at home. This is interesting. The whole part they want this doctor for. This is an allergist, an immunologist, and his testimony is, I couldn't find out what was wrong with her. I couldn't find it out. I can see in the record, and they told us that they'd been to other doctors. They're trying to get another opinion, and he's looking at all the the treatments she's received, and everyone's just saying we don't know what it is, and possibly giving her steroids. And so everyone's prescribing steroids, but nobody's saying CRPS at this moment. He had concern about the level of steroids, and since it didn't add up to him, where he doesn't have expertise in that,
okay, members of the jury,
did not
you
add
were to
up.
disregard the last comment about home steroids. Mr. Hunter, you may continue.
You just unrung the bell. You guys didn't hear that.
Doctor, have we ever met?
I'm sorry?
Have we ever met? You and I ever met?
No, sir.
Have we ever spoken?
No, sir.
Your witness.
It shouldn't waste too much time on this guy. They really can't. They've only got 9.5 hours left on the plaintiff. Defense has 34 10 hours starting this morning remaining. 34 hours, 10 minutes. Sorry. I can do math.
You gave a deposition in this case, you recall?
Yes, sir.
Right. And I just couldn't help but notice how emphatic you were here in front of the jury. You wanted to really convince the jury of what you were saying, right?
I'm sorry. Can you ask that question again, please?
Yes. I noticed you were quite emphatic. You were trying to convince the jury of things you were saying. Were you not?
That's not correct, sir.
All right.
I'm going to sustain the objection.
After the deposition, when the different lawyers were still on the line for ordering the deposition transcript, I want you to tell the jury whether you had a discussion with one of those lawyers in which you said words to the effect of, I did my very best for you, I hope I helped.
Object.
Did you say that to him?
No, sir.
Objection, Your Honor. Proper impeachment.
Whoa.
I'm going to sustain the improper impeachment objection, but you can continue along this line if you want.
Did you, I'm just simply asking you, sir, did you have a discussion with the defense counsel at the conclusion of the deposition while the lawyers were talking about ordering the depositions where you said words to the effect of, I hope I helped you, I did my best to help you, or words to that effect?
Objection, Your Honor. May we approach and maybe show the witness what he's...
I do not recollect those comments.
The answer is we don't need to approach on that. Overrule the objection.
No approach, overrule
and
objection.
You are aware, are you not, that...
He said he didn't recollect, so are you going to refresh his recollection, or are you moving on?
I have other evidence that will be as part of our rebuttal.
All right.
Witnesses. And you are aware that Munchausen by proxy, that reflex sympathetic dystrophy, and you know that's also known as CRPS, right? Mm-hmm. You're aware of that?
Yes, sir.
And you are aware that it is often misdiagnosed as a psychiatric condition, particularly in children, right? Are you aware of that?
So I understand the question correctly. You're asking me if I'm aware that CRPS is often misdiagnosed as a psychiatric condition. Is that the question?
Especially in children.
And my short answer is no, because you mentioned the word often, and I'm not sure that that's accurate.
All right. Well, certainly then you do keep up with the laws that come into effect regarding. I'm going to have to approach before I finish this question.
Mr. Anderson knows he's walking a careful little line here. The witness restating the question like this. The witness restating the question like that. I'm not sure if the witness has been told that defense has very little time left, but that's eating time. He perfectly understood the question. It was a clear question. Mr. Anderson has asked confusing questions in the past, but to restate it very carefully, meticulously, it almost seems like I'm intentionally drawing out this cross. And we'll see if that continues. If it's just a one-off, then I'll withdraw my allegation there. But if that continues in more questions, it might show that he's literally trying to help the defense in any way he can, even by burning time. Nancy, thank you very much. I don't think we have many FOIA requests out there right now, but more will come soon. We've got some for Sarah Boone and still waiting on those, but we'll see. Thank you very much. I appreciate that, Nancy. Let's see. Just here for the jury questions, says Elizabeth. The jury questions have been so good, so good. This is telling. Oh, I probably could. Oh, they've got the sound machine on, so I can't. There's no sound. I was just checking on Zoom. And the yelling you hear in the background is my kid playing. I'm not sure what he's doing, but he's having fun doing it. It's very loud. FOIA is a Freedom of Information Act request. Some of them, the request is free, almost always. The request is free. Just getting them to produce the paper seems to be very expensive, and making copies of video seems to be very expensive. But that's all. I'm not asking for any specific request right now. So if there was a trial we were watching that had a very a pertinent piece of information that we needed to request, I'd let you know. But right now I don't have anything like that. Emma Elizabeth, happy to be celebrating half a year of insanity with y'all. Emma Elizabeth, thank you very much. Love it. Look at that yellow courthouse by your name. That's wonderful. Seashell says, I'm late. Who is this? This is Dr. Elvin Mendez. He's an allergy immunology doctor. He last saw Maya in 2015. And his testimony today has basically been that he couldn't see anything wrong with her skin. He had a pretty good conversation with her. They told him everything that's going on, but it just nothing added up.
Chat to watch this trial with TY.
Lynn, thank you. I have really appreciated you as a less toxic chat to watch the trial with. Thank you, Lynn. That's a little bit me, but really, I have you, all of this community, to thank for just being respectful in chat. I thank you very much. I could not do this without your cooperation, and the fact that we can get a couple thousand people here and all just behave is wonderful. It speaks to you guys much more than it does to me. So thank you so much. The doctor saying, hope I helped you to the defendant is possible. I don't know. Mr. Anderson clearly is not trying to bring the recording in. I think that would take too much time. I'm not even sure if that part of the recording is available. He says, I think, after the deposition ended, but the lawyers were still on the phone, so maybe there is no recording. So I don't know how he can do that. So he's got, Rob said this was collateral impeachment material that might be coming in. But in asking the question, he paused mid-question and said, Judge, I need to run this one by you before I step where I'm about to go. We'll see if the judge has tentatively given him support. Even though there were some objections into how he worded his impeachment, the judge just said, I'm going to sustain the objection, but you can go down this road if you want to chase this rabbit. I'm saying, yes, this is fair game, just you have to do it properly. The mods are incredible, Mindy. Thank you so much. We have amazing mods here. Do sidebars count in their allotted time? The judge said previously that they don't. He's told that to the jury. I was listening back. I think that was way back on October 5th. It was right about the time of Catherine Beatty's testimony. He was mentioning that he hadn't been counting the sidebar time. But time is an issue. I mean, looking at the date, I mean, the judge said, oh, here we go. Never mind. I don't want to start another conversation with.
You may continue, Mr. Anderson.
But you are aware that Munchausen by proxy and other psychosomatic, that CRPS is often mistaken as a psychosomatic condition, a psychiatric condition.
So again, I respectfully disagree with the often confused with, and I'm not sure it's often.
Okay. Well, you are suggesting that you saw signs of Munchausen by proxy. Is that right?
What I said earlier was that I saw signs of symptoms that did not correlate with the treatment plans that have been provided in the past.
All right. And where did you get that information from?
From the records that were reviewed by that were sent to me by other physicians that had seen her. Including
Dr. Kreisman?
Yes.
And Dr. Kreisman, I assume you determined, was the primary prescriber of the steroids?
I disagree with that comment as well. I'm not sure he's the primary prescriber. I just know he's one of the treating physicians.
Well, was he a prescriber of the steroids or not?
On the notes that I read, I do not recollect that, no, sir.
Okay. Now, if you needed to know about whether a child had asthma, actually witnessing it would be a good idea, right?
No, sir.
You don't need to witness the actual cough to know whether or not a child may have asthma?
There's a lot of other causes of cough, sir, that are not necessarily asthma.
Mm-hmm. So if I were to show you an actual cough of the child, would that allow you to see whether or not this child had asthma?
Would not, even if you showed it to me.
Okay.
Would not, even if you showed it to me.
Would a diligent parent seeing a very disturbing cough be doing the right thing to bring it to the attention of a physician?
I totally agree, yes, sir.
Calls for conclusion of the witness.
Overruled on that one.
And then, if we could, with the courts, it's in evidence, show Exhibit 2616.
If it's in evidence, yes.
This is the video with her coughing, right?
Could you not flag, please?
While you're finding it there.
It's playing right now.
Okay.
Be strong.
Now, with a 9-year-old girl exhibiting a cough like that, you would agree that it would be reasonable for a parent to want to search for any possible causes, would you not?
Yes, sir.
So, Beata Kowalski, by trying to find the solution, if you will, that is the correct diagnosis and treatment, that would not be unusual, would it?
I'm sorry, can you repeat the question again?
Beata Kowalski, as a parent, hearing a child with that level of coughing, it would not be outside the bounds of normal parental behavior to try to find out the source of that cough, true?
It would not be, no.
And it would not be beyond the bounds of normal parental behavior to try to find a treatment for that cough, would it?
You're talking about professional treatment? No, not at all.
And so, in going after and trying to find this out, she would not be doing anything that you felt was inappropriate, right?
At this point, from the way that I heard that cough, I'm moving forward? No.
All right. Okay. So, what is certainly you've talked about here and felt strongly enough, I guess, to write a letter. But by the way, did you ever talk to Dr. Kreisman about your concerns that this might all be psychosomatic?
He's not the primary physician.
Did you ever talk to Dr. Wasserman?
I sent him a letter twice explaining that. Well, the first, second time, rather.
If you were really, and so you didn't get a response, right?
Did not, no, sir.
All right. And you never called anyone from the state, did you?
just because I suspected, with the information I had, I personally at the time I did not feel I had to report it. I wanted the primary to be aware of it.
My question then is, did you call the primary care physician and have a discussion with him?
No, sir. That's not customary of me. Not in that situation.
I thought you testified on direct that it was customary, that you would contact.
I specifically said, if we go back to what I said, is that every physician, primary care physician, receives correspondence from me on every visit that I see in my office. The only exceptions are when the patient does not, or parent does not give us the name of the primary care physician.
Tell us then what the facts there that you took from the history with Beata Kowalski that were significant to you, that she uttered to you there. Either visit.
So I want you to explain to me what you mean by facts, sir.
Well, what were the key facts in the history that you found pertinent to trying to come to some conclusions, including this one?
That she has, her daughter has always been ill, that her daughter has been in pain from some neurological problem, that she has severe asthma, that she has an immune deficiency, and what else? And that she has allergies.
All right. And so, allergies. All right. And first, with allergies, did it come to your attention that other physicians had diagnosed her with allergies?
That is correct, yes, sir.
Did it come to your attention that other physicians had diagnosed her with asthma?
I did not have evidence to substantiate that.
Subsequently, did you obtain evidence of that?
I obtained evidence that did not show that she had asthma.
Did you ever talk to any of the physicians at Johns Hopkins Children's Hospital to see whether asthma was listed as one of her illnesses?
My role in all this is to determine whether Maya at the time was immune deficiency. The rest of the information available in history taking is to determine whether there is some correlation between diseases and her apparent immune deficiency. So the answer is no. We do not proceed with any other disorder that I might encounter during my history taking. That is passed down to the primary care physician in writing.
I understand. And then she told you the child had pain, correct?
Pain and cramping on the legs, I believe it was.
Uh-huh. And you said you inspected her. Counsel asked you about her skin. Did you look at her lower back?
No, sir.
Did you look at the inside of her thighs?
No, sir.
Did you look on the inside of her ankles?
Yes, sir.
Did you look then on her neck or upper back?
No, sir.
The inside of her arms?
Anything that was visible during office visit is what we usually put down. I'm not a dermatologist. My role is strictly what I can see. I'm not going to address a patient with a full physical. That's out of my scope of my job.
So whether she had CRPS lesions at that time or not, you would not be in a position to state. True?
I'm sorry, whether she has
CRPS lesions, you would not be in a position to state.
I am not familiar with CRPS lesions.
All right. And so then what was the final one there? The daughter had been sick, right?
Correct.
And you knew that the daughter had been taken, among others, to Johns Hopkins Children's Hospital for various emergency room visits, correct?
I do not have that information, no.
Right. So, out of all of these, can you tell us now, do you know what DSM-5 is?
That's the most recent DSM, yes.
And what is DSM?
So the American Psychiatric Association has a manual, so to speak, that provides you with diagnosis code of various behavioral and psychiatric diagnoses. Yeah. They're up to the 5th edition.
All right. But what does DSM-MD stand for?
Oh, if I can recollect, again, I'm not a psychiatrist. It stands for, oh my goodness, and I don't recall off the top of my head. I apologize.
All right. So, having been raised concerns about this, tell us which of the 4 factors you focused on to come to the conclusion that Munchausen syndrome by proxy must be suspect.
Objection, improper impeachment, Your Honor.
Overruled. You can answer.
So which of the above is what you're telling me that I derived on? Obviously, the main reason for the visit was...
Maybe I misstated. I'd like to know under the DSM-5 categories, the 4 primary categories for diagnosing Munchausen by proxy, or now practitioner's disorder on another. Which ones did you focus on?
1.
And which one was that?
Where there's no correlation between the symptoms and signs presented by the parent and the objective findings that you may have, whether it's radiology or lab work or whatever objective labs or procedures you have available.
The parent told you the child was ill, correct?
That's correct.
The child was moaning.
I'm sorry, the child was?
Moaning.
That's correct.
You had confirmed with other physicians that there are allergies.
What does moaning and pain have to do with allergies? I'm sorry, I lost that.
All right. Well, I'm just trying to find out which of these 4 now, we're talking about the DSM categories, which of these 4 are you saying that Beata Kowalski lied to you about?
So if you all read my notes, both notes, and I have to expand on this, Your Honor, if you don't mind.
Go ahead and answer the question.
To answer the question, I have to explain. He's looking at a very narrowed comment. You have to look at the whole visit. There was a change from moaning and discomfort on the first visit to normalcy, which I thought was striking. The first time I get it, there was something wrong with it. That's why we requested records. The second time, it was complete opposite behaviors. Wheelchair bound, on a laptop, very happy, very distracted with whatever she was doing at the time. And I remember specifically, this is where it hit me, when I talked about how the workup that I had done did not prove immunodeficiency, and I wasn't aware of how I could explain everything else going on. And then she went into this phase of crying, and my ear hurt, and I have a headache. So after that was over, and I tried to find out what was wrong with her, and I tried to ask Mom, "Are you okay?" Then when the visit was over, as she's wheeled out to the waiting area, everything normal again. So you asked me about that narrow comment you made. I'm looking at a whole picture that led me to believe there's something not right about this. That's all.
Well, tell me then what the primary symptom then is under DSM-5. Strike it. Do you have any information whatsoever that Beata Kowalski falsified any fact?
I'm sorry. Okay, let me reframe that question. So you're asking me if I'm aware that Mrs. Kowalski lied about...
Doctor, what I'm asking you is whether you have any direct evidence that Beata Kowalski, based on your 2 visits with her, falsified to you any fact.
No, sir.
No further questions. Sit down. The jury can handle it from here.
And can you remember whether the first element of Munchausen by proxy leads off with falsification of physical or psychological signs?
Objection.
You don't remember that off?
For use of an authoritative assault.
Okay. I'm going to sustain that one.
Would it refresh your recollection to show you the DSM-5 in that regard?
So you're giving me 1 of 4. So just to...
Why don't, hold on, before you answer, why don't you all approach?
Just says, children, gather round. We're going to talk this over. It's so loud. Okay, there we go. Okay, so I am nervous. I'm developing an ulcer as I watch the clock tick, and I know that we've got the plaintiff in their role as cross-examining witnesses has been using an hour 15, hour 40 every day. They have 9.5 hours left. And Mr. Anderson, as much as I love him, is probably the primary cause of why they're using so much time. He does a great job. In this case, I don't think the testimony, the immunology allergist testimony that we got with this, hey, I was just concerned that there was Munchausen by proxy. I don't think that had the impact that Mr. Anderson might think it could with the jury. I don't think that this resonates with them. It's like, there's a smoking gun.
The Diagnostic and Statistical Manual of Mental Disorders, DSM-5, as authoritative on Munchausen by proxy, now known as factitious disorder imposed on another.
I believe that the term utilized now is known as medical child abuse. It is not fictitious. So I believe the more recent diagnosis is different. But I'm not familiar with the manual as it is outside of the scope of my practice.
So you...
Not familiar.
So if I showed this to you now, you wouldn't know what the elements were.
You can tell me what the elements are, but it's really beyond the scope. All I can tell you is we are trained, if we see anything that we may perceive as harmful to a child, that we have an obligation to pass out that information to someone. And my first person was to the primary care physician, who knows that patient more than anyone else.
Would you like to see, would it refresh your recollection to see the very first words on the diagnosis of factitious disorder imposed on another?
Objection to proper foundation.
I do not feel that just looking at one item of 4 is going to help us change our gut instinct of us feeling that you may have in a child in your office that you feel might have been in danger. And I'm being honest.
And I'm being honest.
Mr. Hunter?
Add that little qualification. Here comes the jury.
Members of the jury, any questions? Okay, given the number of notes being submitted, once all the notes are collected, I'm going to ask you to go back to the room. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All right.
This means we should be able to hear these. We'll get the audio on this one, I think, because the doctor's going to be out, the jury's going to be out, so there's no reason for them to use white noise. We should have the sounds turned on for this. I'll start repeating what I hear just in case the audio guy decides not to turn it on for some reason, but this is something that everyone in court is able to hear. Okay, Dr. Mendez.
Out of our presence. Dr. Mendez, I need you to step outside.
The transcript will reflect that I'm adding onto each page a red number just to help us keep track of which page I'm looking at and whether I'm going to read the questions or not. So red number 1, did doctors at All Children's Hospital think that Maya had asthma and treat her with it? Number 2 in that page, before you saw Maya, did you know what CRPS was and how it affects people? No objections, says Mr. Anderson. No objections for Mr. Hunter either. I'm a human tape recorder. Red page number 2, says the judge. Did you notice any signs on did you know any signs or lab numbers that showed Maya was getting ketamine treatments? Did you ask or know why Maya was in the wheelchair? No objection from Mr. Anderson or Mr. Hunter. Red page number 3. I see you have concerned possible Munchausen by proxy enough to document in Maya's medical records as a mandatory reporter in the state of Florida. Did you call and report this to CPS? If not, why not? Then it says, especially if you had DSM criteria as you testified as mandatory reporter, should you have reported to CPS? No objection, says Anderson. Mr. Hunter says, I think he testified to this, Judge. Judge said he didn't call. Mr. Hunter says, but he was crossed about that as well, so I would object to that one. They're objecting based on asked and answered. Judge says, I'm going to rule based on the objection. I'm going to ask the 2 questions there. Actually, 3. Judge says, next, read page number 4. After you mentioned your training, and especially any of these trainings with CRPS, or the older term known as, I don't recall the initials, in parentheses, was this CRPS part of those specialties? That was a really jumbled question. No objection from Mr. Anderson. Red number 5, said the judge. Upon your first meeting with Maya in October 2015, Maya was in a wheelchair. Do you recall what was Maya or Beata's explanation for the need of a wheelchair? Ooh, good question. During the December visit, I may not have heard, but was Maya in a wheelchair on that visit? On this December visit, was any pain issues mentioned as possibly the visit's initial daily interview? Any signs of dystonia? Was Maya in long or short pants? Then it says, parentheses, shorts have been mentioned as less touching on skin, less pain in parentheses. Socks or shoes, or sandals and flip-flops. They want to know what she was wearing. Ms. Krell says, I think we object to the commentary, but besides that, no objection, and no objection from Mr. Anderson either. Judge is going to admit the commentary about the shorts. Red number 6. Doctor, you mentioned that based on examination of Maya and reviewing of testing results, you came to believe Maya suffered from Munchausen by proxy, or a similar term, yes or no? If yes, how many cases of Munchausen by proxy have you encountered up until 2015? No objection from Mr. Anderson. Defense is thinking it over. No objection from Mr. Hunter. Anything else before we bring in the jury? Just 2 things. Ms. Carell says, we're going to take a break after these questions are asked. The judge says, what's your next witness? Mr. Hunter says, Dr. Richard Elliott or Dr. Kastenstein. Either one will be long. Judge says, why don't we take 5 minutes right now, and then we'll come back and proceed. Tells the bailiff, can you tell the jury 5 minutes? We're going to try to keep it to 5 minutes. Mr. Mr. Whitney's name said, Your Honor, do you have the 11:55 hard stop? And he said, I do. So he has a lunchtime appointment. Okay, there's just some little chatter going on that's really quiet. I can't pick it up right now. But everyone's returning to their places, and now we're on break. So now we have a 5-minute break. Okay, so what I'm doing is what I have on my phone is I have the court Zoom feed. The Zoom feed is available, but it cannot be by rule. It cannot be played. And I can't even take screenshots. I can't show you the video. I can't let you hear the audio. And so what I can do is I can listen to it and tell you what I hear. So I'm trying to let you know that this previously in this court, the guys who are running the audio stream did allow or did leave the audio turned up during these breaks. But lately, during these juror question reviews, they've been turning it off. So the sound is on in the courtroom. Anyone would be able to hear. So anyone sitting in the court would not know that the live feed was not turned on. So I'm just bringing you that. All right. Let's see. Do we miss anything spicy? Little Miss, it's getting to be a spicy day. It really is. I think we've got some big issues that have to be decided. The first argument, the one we had with the sort of started on Friday with the judge saying, I need you guys to sort out, what you're arguing for and what you aren't. And are you going to include Munchausen by proxy plaintiff and sort of wrap that into some of your allegation and defense? On Friday, Mr. Shapiro was saying, if you're not going to include it, then I don't have to bring in all this stuff. It'll save us all this time. Today, they sang a different song. Today, they said everything we do revolves around Munchausen by proxy as a defense for what the hospital did. So Mr. Shapiro might have been speaking a little out of turn on Friday. Cielo says, objections at sidebar 2. 1, no objections. 2, no objections. 3, defense objects. 4, no objection. 5, defense objects to commentary. 6, no objection. Okay, thank you for keeping score. Appreciate that. Where are we at on the objection list? Here's where we are. Let me bring this on. All right, we were at, Dr. Jennifer had 12:05 was her guess. So we've gone past a few people here. I apologize. We'll scroll up. Have an easy day. I see you there. Cindy's crazy. We just passed you, Sandy. Kind of, sort of, in the way is, well, it's right here. We're sort of right between kind of, sort of, in a way, and Jets Benny is tied on your guess as far as the objection count. So we'll keep that up to date. Do you think they'll bring Sally Smith last minute? Yes. I think they will definitely wait until the plaintiff has no time left to cross before they bring her in. Pauline, is it Anais? Anais Pauline? The courthouses, those are indications of membership on the channel. Membership is not required, but if you do feel you want to support the channel financially, you can become a member, and that colored courthouse changes color over time the longer you've been a member. So if you've been a member for 6 months or longer, that's going to be yellow, and that's, since we're a fairly new channel, that's as far as you could be right now. But thanks for the question. Okay, I'd like to object to my objection count. Judy, you guessed low. It's all right. We're going to do another. We'll have another contest here soon. Selena K says, I have 10 months sober today. Watching this channel gives me a distraction, which I need. Thanks, RA in chat. Selena, congratulations on 10 months of sobriety. That's amazing. We're all cheering here for you. I think I've even got a cheering sound I can use here if it's not too loud. There we go. We're all cheering for you. That is huge. 10 months is amazing. 1 day is amazing, but 10 months of days together is incredible. Thank you. You got this. It's so excited for you. If they bring in Sally Smith, they might as well bring a checkbook. I don't know. I would like to see her in person. We've already seen her on the in the video deposition, but I'd like to see her in person. So that would be a very, very interesting. Well, it might only be direct, but even that might be very telling. Kayla Toth says, first day watching live with you. I can't wait. Thank you, Kayla. Welcome. Good to have you here. We have just a 5-minute break here and it sounds like it's going to have a long, let's see, they've got 11:55 hard break. So we come back, you get the juror questions, any follow-up from either side, which I hope Mr. Anderson doesn't ask anymore. I don't think he needs to get anything more out of this witness, and I don't think anything that the jurors ask is going to elicit just that smoking gun testimony that he can get from the witness. So I think he should have sat down. I would have not been disappointed if Mr. Anderson said no questions for this witness, because I think that it was fairly clear that had already testified on direct that CRPS is way out of his arena. He has no clue about that. He has no idea about that or any expertise in that area. And he's just like, well, it's clearly not allergies, so it must be Munchausen by proxy. That's all he gave the jury. And I don't think that the jurors sitting there is like, well, that's it. 2015 MVP, case closed. I just don't think that this was that powerhouse witness the defense maybe hoped it was. I feel like I can hear Rob from Lawn Lumber yelling, "Sit down," to Mr. Anderson. I think you heard and saw that. It came across chat a couple times. Last question. Let's see. Can I ask what the original premise of your channel name is based on? Maybe a story time? Yeah, we'll do that. I can do that in story time, I'll tell you. I'd be happy to share it.
Thanks. Let's get Dr. Mendez as well while we're working at it.
Anderson is like Apple, where he says where they do the one more thing. He's got one more thing he wants to get out. He's a great attorney. I was critical of him initially, and I'm critical a little bit of his time management. But the guy is phenomenal. Look at what he's dealing with. Look at how much he personally handles in this case, where you've got so many players on the other side that are divided to conquer. And look at everything he handles, and it's impressive. Mr. Whitney's just right behind him as well, just incredible. I love hearing Mr. Whitney argue on his feet. When I hear Mr. Whitney argue, I can hear him playing chess in his head. Like, he's not going to blurt something out that will come back and bite him, because he knows what the next three moves are. And I love that. Here in 11 months. That's awesome. Congratulations.
Okay, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation, received no information. Is that all correct? Correct. And none of you saw any media accounts about this case since you were last with us? And no one approached you. Is that correct? Correct. And just to remind you, I did discuss these questions with the lawyers outside the presence of the witness. Doctor, the jury has several questions for you. Did the doctors at All Children's Hospital think that Maya had asthma and treat her with it?
Are we referring to the pulmonologist, Dr. Kreisman?
Do the best you can to answer the question.
So I don't have records from All Children's Hospital. I want to be clear. The only records I received was from Dr. Kreisman from the visit after she was discharged from the hospital. And then the question is, do I have evidence that she had asthma?
And did the doctors at Johns Hopkins All Children's Hospital think that Maya had asthma and treat her with it?
So based on the records, there's a normal spirometry, meaning breathing, the pulmonary function test was normal, but he had advised to continue on a inhaler that was prescribed in a course of tapering corticosteroids.
Before you saw Maya, did you know what CRPS was and how it affects people?
It's a great question. To some degree, I have a lot of veterans in my practice. I see adults and pediatrics. That's the treating we have. It's not just pediatrics. So we would have folks that come in with some complex pains that I would hear from the VA notes of the possibility that they may have CRPS. But I wasn't familiar with the disease. I just know they complain about kind of phantom pains and burning sensation on skin. That's my only recollection of that disease.
Did you notice any signs or lab numbers that showed Maya was getting ketamine treatments?
That's a great question. So let me try to explain So I wasn't aware she was receiving ketamine treatments until the second visit. Was there anything that I would expect? I have no idea. I'm not familiar with ketamine treatments in the U.S. to begin with. I was surprised that she had gone to Mexico to have that done. So my short answer is no. I'm not aware of any abnormal labs that might be linked to some treatment she received outside of the country.
Did you ask or know why Maya was in a wheelchair?
Yes, sir. We did on the first visit, and she did tell me that there was pain and spasms is what she was describing. She did mention she mentioned the word RDS when we first met. However, I wasn't familiar with the disease. I had an idea of what it might be, but I clearly said it's outside of my scope, and I think I alluded to that in my notes. Have follow up with primary care or neurology for these, because I don't know how to manage those.
The next question. I see you had concern of possible Munchausen syndrome by proxy enough to document in Maya's medical record. As a mandatory reporter in the state of Florida, did you call and report this to CPS?
That's a great question, and the reason I didn't do so, and I apologize if I didn't allude to this in the past, you can have hunch instincts of things. I'm the one guy who's seen this person twice in my office with an extensive medical history, and I reached out to the one person who would know from any other specialist that has seen this child will have an idea of what's going on with her. I'm just, like I said, one small part of her life in that less than a year that she was having these symptoms. So my reach out was not to the state, sir. It was actually reaching out to the primary doc. Listen, is this something that you've considered? That was all. I don't want to report something like this where I'm not 100% certain that that's what's going on. It was a red flag, basically, is what I'm sending out there.
Okay. Well, he already answered the why not question, so we'll move on to the next one. Doctor, you mentioned your training and specialties. In any of those specialties, was CRPS, or the older term that it is known as, was this CRPS part of those specialties?
Good question, and the answer is no. Understand, we're referring to the allergy immunology, we're referring to both allergy and pediatrics. I'm not sure, but let's assume we're looking at both. The short answer would be no. RDS, to be quite honest with you, at my time of training, probably was just like fibromyalgia, other diseases where we think there's something there, but we don't have evidence of substantiate or objective ways of treating it. So my short answer is no, we do not.
And this next question is similar to another juror's questions. Upon your first meeting with Maya in October 2015, Maya was in a wheelchair. Do you recall what was Maya or Beata's explanation for the need of a wheelchair?
Well, similar to what I said earlier, I wasn't given a diagnosis until towards the end, where she mentioned RDS. But she was doing we do a review of systems, so we kind of go over each organ and ask questions. And that came up as part of her neurological, that she does have spasms and pains. And also, I think she mentioned headaches. And she corrected me and said that headaches are part of RDS.
During the December visit, was Maya in a wheelchair on that visit?
Yes, she was. Unlike the previous visit, she was in no pain or distress. She was on an iPad. I remember it clearly because I thought it was pretty neat that she was actually doing a Word document. So I don't know if she was writing the story or something. It just struck me as a young kid doing that. That was pretty neat.
On this December visit, was any or were any pain issues mentioned like the visit's initial daily interview?
I'm sorry, can you repeat that question?
Yeah, let me just read it verbatim. On this December visit, was any pain issues mentioned as possibly the visit's initial daily interview?
No, it was not. That did not come up. The purpose of the second visit, as it always usually is to follow up on anything that I do and to review the records. And she did bring additional records to that visit, but it was not mentioned at all. She did go into, like I said, some sort of a spasm towards the end of the visit when I was giving her a summary of my findings, and I thought that was kind of odd.
When you said spasm, you mean Maya or Mrs.?
I'm sorry, Maya did, yeah.
Okay. During the December visit, did you see any signs of dystonia?
No. So so assuming we're referring to dystonia as muscle cramping or some changes associated with muscle cramping, usually the lower legs are the more common. I'm assuming that's what we're referring to. I did not. There was a physical examination done on both visits, and both visits did not correlate with any. Again, for the best of my abilities, I don't do a full neurological exam. I'm not a neurologist, but I did not see any joint aches and pains when I examined her. I did not see from visible skin lesions at all. So my short answer is I did not.
Was Maya in long or short pants?
Ooh, that's a great question. I'm trying to remember. I remember I was able to see her ankles. That's all I can tell you, and I believe she may have had not long or short pants. What do they call them? Capris? So short, yeah. That's what I remember. It's 8 years ago. I'm sorry, guys.
Was she wearing socks, shoes, sandals, flip-flops?
Do not recall that part, no. And I don't believe she was wearing footwear, but I just don't remember the top of my head.
Next question. And this was prefaced as a yes or no from the juror. You mentioned that based on your examination of Maya and reviewing of testing results, you came to believe Maya suffered from Munchausen syndrome by proxy or similar term?
And you're asking for a yes and no answer?
You can expound, but why don't you first start off with yes or no?
It cannot be a yes and no answer. I can only say suspect, and I'm required to raise a red flag somewhere. I have to reach out for somebody to help.
He's required.
How many cases of Munchausen by proxy had you encountered up until 2015?
This is probably my second in my career, so that would be 2.
That completes the asking of the juror questions. Mr. Hunter, do you have anything in follow-up?
No, Your Honor.
Mr. Anderson, do you have anything in follow-up?
So you defer to Dr. Wassenauer on as to whether there really was Munchausen by proxy or not. True.
In my letter, yes, sir.
Thank you.
Any follow-up to that? Members of the jury, any further follow-up? Okay, may this doctor be released?
Yes, by plaintiff.
Yes, sir, Your Honor.
Sir, thank you very much.
Okay, I don't know exactly what the time was that he used, but that I would estimate it's between 15 and 20 minutes.
We called Dr. Jennifer Katzenstein.
And that's on the plaintiff time, which would mean he's got just over 9 hours left. Okay, we got Dr. Kassenstein. I cannot say this name. Is it Kastenstein or Kassenstein? That last little question Mr. Anderson asked was an important one. Basically, do you refer to the primary care physician as to whether there was MBP? And he said yes. And I believe that primary care physician said there was not MBP. Crazy that at the very end he's like, oh, and there were some muscle spasms, and she did say there was pain, and that wasn't what I was paying attention to.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, nothing but the truth? I do.
Well, come this way.
Yeah, please. Good morning.
Good morning.
If you could introduce yourself to the jury, please.
My name is Jennifer Katzenstein.
Okay. And what's your profession?
I'm a pediatric neuropsychologist.
Okay. So let's talk a little bit about what the road to becoming a pediatric neuropsychologist.
I'm sorry to interrupt, but
yeah, so you might need to...
get closer?
Yeah, sit a little closer to the microphone, pull it near you. There you go. Start at basics. Let's see if everyone can hear you. Introduce yourself to the jury.
My name is Jennifer Katzenstein.
I think that's going to work.
Better? Okay.
So, a pediatric neuropsychologist, where did you go to undergrad?
I went to undergraduate school at Lafayette College.
Okay. And what did you graduate with?
Bachelor's of Science in Neuroscience.
And then after you graduated with your Bachelor of Science in Neuroscience, where did you go to school next?
I went to graduate school for my master's and my doctorate degree at Purdue's campus in Indianapolis.
Okay. And did you achieve your doctorate?
I did.
Not to
age you, but I gotta ask, what year did you graduate?
2008.
Okay. Well, and after you graduated, where did you go next?
I went to fellowship, which is a 2-year placement at Texas Children's Hospital in Houston, Texas.
Okay. Maybe you could look to the jury and explain to them what is a fellowship training? What does that entail?
So for psychology, it's similar to physicians. We spend 1 year as an intern at a placement somewhere across the country in order to get your degree. And then after that, you have to have a number of supervised hours to be able to be considered license eligible across the country. And so for me and for pediatric neuropsychology, we're required to have a 2-year placement in order to be board eligible. So that was my 2 years of training after my degree was completed.
Did you achieve board certification?
I've achieved board certification by the American Board of Professional Psychology in both clinical neuropsychology and subspecialty in pediatric neuropsychology.
And do you retain those board certifications today?
I do.
Okay. What's your focus?
My focus as a pediatric neuropsychologist is on how the brain impacts behavior and cognitive functioning, and how we can best support children in determining their educational and vocational needs based upon their cognitive strengths and weaknesses.
Okay. So, how long have you been working at All Children's Hospital?
I've been working at All Children's for just over 8 years.
Okay. So if we work backwards, do you remember when you started, what year?
July 2015.
Great. All your work is in pediatrics?
All of my work has been in pediatrics.
Are you familiar in general with the diagnosis of pain as a component of pediatric disorders?
I am.
What percentage of your practice is devoted to working with children who have pain?
That's challenging to say because kids have varying levels of pain throughout multiple different types of medical treatments. So I would say many of my patients have some level of pain as it relates to their medical history or their current medical treatments.
Okay. So we're going to talk about what your role is, but I'm going to try to let the jury understand from you what your role would not be. You're not a medical doctor that makes a medical diagnosis. Is that fair?
I'm not a medical doctor.
Okay. So I think one of the things the jury might want to know, are you going to be telling this jury whether Maya has or does not have CRPS?
I will not be speaking, confirming, or denying any medical diagnosis.
Okay. So let's talk a little bit about pain scores, because the jury's heard a little bit about pain scores. How do you take a pain score from a child?
So with kids, it's more complicated because pain is subjective and pain is very specific to the individual. So for kids and for many people, we have a scale of 1 to 10. For kids, it has little faces next to it as well, where we say a 1 would be no pain and a 10 would be the most pain you've ever felt, and ask them to give a rating or point to the smiley face along that pain scale.
Okay. So is it subjective?
It is subjective.
Okay. What do you normally see in a child who's reporting 10 out of 10 pain?
In a child who would be experiencing a 10 out of 10 pain, that should be the most significant pain they've ever had. And so that would be, from my observation, something like lying on their bed, maybe curled up, not willing to speak, maybe feeling nauseous, vomiting, not even being able to speak, maybe even screaming because of the pain that they're experiencing being so severe.
You've had a chance to evaluate children who deal with chronic pain?
I have had some children with chronic pain in my practice.
Do children with chronic pain generally report higher or lower scores of their pain?
It really depends. Our pain is specific to who we are and also our perception of that pain. And so when maybe someone says, I have a really high pain tolerance, they might rate their pain a little bit lower because their worst, most significant pain or their perception of that is higher than maybe someone who doesn't have that same perception of pain or understanding of their own pain.
So I'm going to ask you about some of your interactions with Maya and her family. Okay. We're going to start, Clay, with Joint Exhibit 1001-3748, which is in evidence. If you could put that up, please. And we can probably focus in where your psychology consult note begins. Just sort of talking about this note, if you can tell the jury, what was your purpose of trying to meet with Maya on this day?
Yeah. This would have been the day that the consult would have been received by the psychology service to complete this request by our medical team. In this initial note, I'm looking here, I was meeting with the pain team to discuss the plan of care, and I introduced myself to the family Oftentimes in these situations, there's numerous providers in and out of the room, so we were working to schedule a time so that we could speak all together.
And just so the jury's aware, is most of your practice on the campus inside the hospital, or is it off campus?
For my practice, primarily, I'm an outpatient provider, meaning that I do clinics that are in a separate building from the hospital. However, at this time, we had 3 psychologists, and we each rotated on call every week. And so when those times came up and a consult was received and I was on call, I would be inpatient for those required appointments, consultations, needs for my patients, and also outpatient during my clinic time as well.
Okay. So during this first time that you had spent with the Kowalskis on 1010, did they ever express to you a desire to leave all children?
No.
Okay. Let me talk to you about your next note. It's on Joint Exhibit 1001-332. Sorry, yes, 1001-3832. And if you could pull out where her note begins, this would be the next day, October 11th. Is that correct?
Correct.
There's a statement in here about the interview history, about why you were being consulted. Can you tell the jury why you were being consulted on this day?
Initially, my understanding of the consultation was that Nemours wanted to have a measure of cognitive functioning, or IQ, completed as part of the transfer request. But as I became involved and met with the medical team, that had evolved over time to supporting the family during the hospitalization.
Okay, so we'll talk about your role in terms of supporting the family and supporting Maya going forward, but there's a discussion of Nemours. Did you have some familiarity yourself in terms of what Nemours could provide?
I did. About 6 months prior to this, myself and another anesthesiologist had traveled to Nemours to observe the program. We were interested in putting together a business plan to do something similarly, and spent the day with the team at Nemours observing their physical therapist, occupational therapist, their psychological therapist, and then also working with their physician to get an overview of the components of the program and then how the day was set up for each patient involved.
In your note, on the second sentence, it says, this has evolved to provide supports for the family and discuss the importance of cognitive behavioral therapy and pain management. Do you see that?
Correct.
Can you explain to the jury, what is cognitive behavioral therapy?
Cognitive behavioral therapy is a therapy that we use as psychologists and therapists. It's evidence-based. It actually has quite a bit of support behind it as the standard of care for many psychological conditions, and can help with the stress and anxiety related to medical conditions as well. But what it is we look at how our thoughts impact our feelings and our behaviors. And so we talk through different coping strategies, an understanding of the interplay between our stress, our anxiety, our mood, and those thoughts, and then work to address the thoughts to in turn improve our mood, our feelings, our behavior.
From your perspective as a neuropsychologist working with Maya to provide cognitive behavioral therapy, does it matter the source, meaning whether it's psychogenic pain or an underlying illness?
Interestingly, for many conditions, psychological and otherwise, cognitive behavioral therapy is a strong therapeutic technique regardless of diagnosis.
Okay. Let me turn to the next page, Clays 333. And this is page 2 of your note, and I'll direct your attention to the top. Do you recall, or does this help refresh you, that you had met with Maya and her father the previous day?
Mm-hmm.
So you're coming back the next day. What is the goal? What are you trying to get?
My goal was to meet with everyone together.
Okay. And does your note reflect whether you were able to eat with Mom, Dad, and Maya all together on this day?
I was not yet able to meet with everyone together.
Okay. It looks like you tried to call Mom to arrange it, and for whatever reason, she just wasn't available at that time.
Correct.
Okay. So we're going to direct your attention now to the next note, the next day, which is Joint Exhibit 3829. And this is now the third day. And just backing up, and I'll cover this for each day, on October 11th, for any interactions they had with the family, did anyone express a desire to leave All Children's?
No.
Okay, so let's talk about 10-12. The next day, this is your third attempt to meet with all of the Kowalskis, is that right?
Yes.
Okay, so let's go to the next page, which is 3830 at the top. And again, it looks like the second paragraph, you were trying to meet with Maya's mom again, is that right?
Correct.
And for whatever reason, she was unavailable to meet with you at this time?
Correct.
Okay. And then you discussed, well, take a look at your note. Did you discuss with the nurse some techniques that she could employ with Maya to help her?
Yes.
And what would those techniques be?
I spoke with the nurse about different ways that she can help Maya calm down, including utilizing deep breathing, some meditation, so again, that calming process for our body. And then sometimes for our kids in the hospital, there's a lot of people in and out of the room. And to give them some control of who comes in and out, we put a stop sign on the door so that maybe for 20 or 30 minutes each day they can say, I don't really want anyone in the room. I don't want to be bothered during this time because there's so much happening medically. Then that way they can put that stop sign out there and really control who's in and out.
It looks like, according to your note, you called mom to meet with you?
I did.
Okay, and at least as of this time, you didn't receive a call back. Is that fair?
Correct.
And Clay, just because we've covered this, but if you can scroll down a little bit on this page where it says medical history, we'll stop there. There's a number of diagnoses here with the medical confirmed. Can you tell this jury how that gets on your note?
Yes, those are entered by the medical team, and when we write notes in the electronic medical record, oftentimes there are pieces of the medical record that automatically come in. And so those pieces of the note are brought in by the different software program and then are not made by me, but are presented by the medical team.
And I think we talked about this at the start of your testimony, but whether these diagnoses exist or do not exist, that's not something that you get involved in. Is that fair?
Correct.
Okay. So let's talk about the next day. You made it looks like another attempt, which is the fourth attempt to have a family meeting, and that's at 1001-3824, please. And we can expand on it a little bit there. Okay. Did you have a chance to meet with the family on this day?
I did.
Okay. All of the Kowalskis?
Correct. Well, my mother and father.
I apologize, right. So it was mom, dad, and mine.
Correct.
Okay. It looks like, at least according to your note, you spent a significant amount of time in conversation?
I did.
Okay. At any point during this meeting on October 13th, did anyone express, and did either Jack or Beata Kowalski express to you a desire that they wanted to leave the hospital?
No.
Objection, straw man.
Objection, straw man.
It looks like you had a long conversation of some of Maya's medical history. Do you see that? In terms of the homebound and
Oh, yes, just scroll a little bit further.
Okay. We'll flip to the next page, Clay, which is 3825, please. And take a minute to review your note if that helps you refresh. I'll ask you a couple of questions about this.
Okay.
You have a comment about halfway down the first paragraph where it says that the school transition caused significant anxiety and exacerbation of her pain. Do you see that?
Yes.
And then the next sentence says her parents reported understanding that anxiety and stress are directly related to her pain.
Yes.
Can you explain from your perspective as a neuropsychologist what the interplay is of that mind-body connection with pain?
Absolutely. So when we have increased anxiety, stress, or other psychological functions, we can see an increase in other physical symptoms as well. And in this case, Maya's parents understood in our discussions that having increased stress and anxiety about having to return to school was related to an increase in pain.
The return to school, did you have an understanding as a neuropsychologist what that meant in terms of how many hours Maya would be receiving at home versus now what she was being asked by the school board to come back to?
Yeah. So in my experience, hospital homebound services means that a teacher comes into the home pre-COVID in person for 2, 3, maybe 5 hours in total per week. And then there's other assignments that the student is doing throughout the week. So going from hospital homebound with a few hours per week of individual teaching supports back into a full school academic setting, I understood could be stressful because that's a big transition.
Okay. In the next paragraph, where it starts with her parents went on to describe the stress, there's a comment at the end of it about mom directing you to a blog and a fundraiser. Do you see that?
I do.
Did you have a conversation with Mrs. Kowalski about whether you should be reviewing the blogs and the fundraising pages?
I recall her offering those to me to provide a better understanding of Maya's condition. However, I indicated that I don't utilize the internet or social media or any other sources for my families because I want to gain that information directly from them.
In the next paragraph, you were discussing your observations with the Nemours Pain Clinic.
Yes.
And I know you gave the jury some understanding of what you knew about it. Would it have been your recollection that you would have recommended to the Kowalskis this being a program that they should consider?
Yes, I continued to recommend that the duration of the hospitalization.
Okay. Let me direct your attention to the next page, which is 3826. Under the histories, it says history limited by. Can you read that for a moment, Doctor? What did you mean by altered mental status and Maya's pain and emotional status?
So as a part of every consultation, we do a mental status so I can report back the current functioning of that individual child. And at this initial consult, where all family members, mom and dad, were present, Maya appeared to have an altered mental status as she wasn't able to report or discuss with me at that time, and mom and dad were providing all of the responses.
Okay. And having met Maya prior, when it was just her and her dad, and now meeting Maya when her mom's present, was there a difference in Maya's affect?
In previous meetings, I had spoken with her, and she had been conversational, and she was not at this meeting.
Let me turn you to 2 pages deeper. It's at 3828. Under the appearance section, what did you know?
I wrote here, Maya was poorly groomed, and her parents reported this to be a change in her demeanor, as she usually takes great pride in self-care.
And then under the social emotional, what did you report?
Anxiety, depression. Maya's parents report significant anxiety and stress exacerbate Maya's pain. In addition, they discuss that she appears more depressed and that her mood has changed because of her pain.
Clay, if you'll scroll down to the assessment and plan to the bottom where there's a diagnosis. What was your diagnosis as of this day after having the family meeting?
At initial meeting, I diagnosed psychological factors affecting other medical conditions severe.
What does that mean? Can you explain that to the jury?
Per the medical record, there were medical diagnoses, and in discussions with parents, they noted that anxiety and stress exacerbate the pain that is related at that time to the medical condition. Severe means hospitalization. So there's different levels, and per our diagnostic and statistical manual that we utilize to diagnose, severe equates directly to hospitalization.
The next line, you have something that says rule out somatic symptom disorder. Can you tell the jury what your thought process was here?
Yeah. Pain disorders, psychological components of pain are complicated, and so in this section of our manual, there are multiple different diagnoses. Somatic symptom disorder is one of them, and what it means is that the physical manifestation or the symptoms related to the medical condition are out of proportion with what the individual is perceiving. And so it might be excessive focus on the symptoms. It may be that the symptoms and the condition become part of one's identity, and that treatment has really taken over their life and become who they are. And I wanted to explore that further as we continued our time together.
The jury's heard at various times a diagnosis called conversion disorder. Are you familiar with what that is?
I am.
Can you explain to the jury what conversion disorder is?
Sure. So also in this chapter is conversion disorder. That's when one or more physical symptoms can't be related to a physical or medical condition. And so it's thought that maybe anxiety, stress, psychological factors are manifesting a physical symptom, and it's not purposeful. This is really a complex interplay of how our mind and our body work, and sometimes related to that, you can see that a patient has a reinforcement for those physical symptoms. And again, our minds are creating these physical symptoms, even though that patient isn't purposefully creating them.
Yeah, and you bring up a good point, doctor. In conversion disorder, that doesn't necessarily mean the patient is faking it. Is that true?
Correct.
Sustained.
Does conversion disorder in your training mean that the patient is faking it?
In conversion disorder, many times the symptoms are real. What's happening is real. It is very much not being rooted in a medical condition, but or faking it, or pretending. These are real symptoms that are happening.
Can you explain to the jury or expand on the concept? You talked about the subconscious level of this. Mm-hmm. What is the interplay of conversion disorder and the subconscious of a patient?
Yeah. Conversion disorder really is in the subconscious. So these symptoms are coming through as a result of significant stressors, psychological or emotional factors. So it is, again, that deeper interplay in our mind where the physical symptoms arise.
Let me direct your attention to 3829, which is the last page of your note, and just if you could go to the top, Clay. You made some recommendations. What did you recommend to the family at the end of this family?
Yep. I would remain available to the patient during the admission, and I'll continue to follow Maya during the admission. And then I was requesting continued follow-up with her outpatient psychotherapy provider, utilizing evidence-based practices, including biofeedback and cognitive behavioral therapy, and then follow-up with Nemours Day Treatment Pain Program.
What was Nemours asking you to do or someone to do on Maya's behalf before transfer?
My understanding for the reason for my consultation was to get a measure of IQ, of cognitive functioning.
Was that task performed by you or Dr. Lewis, or what ultimately happened with that?
Ultimately, that was completed by Dr. Lewis.
Okay. Can you tell the jury why you didn't independently repeat that?
Yeah. So when we utilize measures of IQ, per the standardization of those IQ measures, you can't repeat them within a year. And Dr. Lewis, at that point, was involved in the case. He would be doing an evaluation, and so it wouldn't be within the bounds of each intellectual ability measure to be able to repeat that within a year, let alone a few weeks.
Let me ask you about the next time you saw Maya. We'll go to 3821. And just to orient you, at this point, the shelter order had been in place. Is that right?
On 1014.
Just so we're not getting, I'll represent to you that after this meeting, as of 1014, that there was a shelter order.
Thank you.
Okay. Were you attempting to see Maya the next day to continue cognitive behavioral therapy?
On 1014, I attempted to see her. She was not available, and I'd follow up on Monday.
Okay. So your plan after the 1013 meeting was to continue to see her for cognitive behavioral therapy, but she was in a procedure or something where you can...
Correct.
Plan was to come back Monday?
Correct.
Got it. Okay, so let's talk about the next time you saw her, which would be 3816. And you can just note the date of the time, and I'll just direct you to the page 3820. If you can go to 3820. And you were able to perform cognitive behavioral therapy with Maya on this day?
Yes, on the 17th.
What did you notice about her appearance at this point?
She was appropriately dressed and groomed.
And what did you notice about her orientation?
She was oriented to person, place, time, and situation.
I'm going to direct your attention next to 3813. And I'll note it's at the bottom, Clay. It shows that you attempted to meet with Maya again 2 days later on the 19th. What was the purpose of this meeting?
To continue to consult and provide support.
Okay. And would that also include cognitive behavioral therapy?
Yes.
Let's go to 3814, please, the next page. And if you could focus on the interval history.
Mm-hmm.
And were you able to provide cognitive therapy on this day?
I was not. Maya was not in her room.
And what was your plan?
I would plan to follow up the next day, continue to provide CBT and some guided journaling.
Okay. Let's go to 3810, which is your note from the next day, 1020. And I'll just note that the date of the note Let's go to the next page, which is 3811. Were you able to meet with Maya this day to provide cognitive behavioral therapy?
She was not in her room.
And what was your plan?
I would plan to follow up the same day if I had time, or the next day, and continue to provide CBT and guided journaling.
Okay, so let's go to the next day, which is at 3807. Now we're on October 21st. Were you able to connect with Maya on this day?
I was.
Take a look at your notes. Is this the what are you doing for this section of cognitive behavioral therapy?
Initially, in cognitive behavioral therapy, we start with what's called psychoeducation. So education and information surrounding how symptoms of pain interact with our moods, our emotional functioning, our stress and anxiety. And we started to discuss the role that our thoughts play in physical outcomes, especially tensing up prior to physical therapy as she worries it will be painful.
In the next paragraph, you have this comment about her pain in the second sentence about her pain being expressed to be a 10, but then you have a comment about her affect. Can you describe to the jury what you meant by this?
Yeah. Her affect was quite bright and didn't match what I would perceive a 10 to be, which would be that significant extreme pain.
You were able to complete cognitive behavioral therapy sessions with Maya on this day?
I was.
So let's go to the next note, which would be on October 26th, and Clay, that will be at 3803. Would this be the fourth session of cognitive behavioral therapy you were able to perform with Maya?
Yes.
And was she present to be able to participate?
Yes.
Okay. You have a comment here about, in the second paragraph, about scary movies and our time in Mexico. Can you describe to the jury what that conversation was?
Yeah, and part of our guided entry into her journal, we were talking about different questions. So a guided journal entry would be a question that we were answering together. And so we were completing an entry together of what she was most afraid of. And she indicated that when she was in Mexico receiving treatments, she saw a scary movie, The Ring, and that she was very afraid of that movie.
I'm going to take you to the end of your note at 3806. And you have some recommendations here, Doctor.
I would continue to follow Maya while she was inpatient and provide CBT. And then as discharge was considered, it was highly recommended that she be placed in an inpatient pain program where she can receive frequent cognitive behavioral therapy and biofeedback from a psychologist.
It looks like you attempted to meet with Maya next for cognitive behavioral therapy on October 31st, Halloween. I'll take you to your note at 3799. And if you just look at the interval history, can you tell the jury whether you were able to do cognitive behavioral therapy on this day?
I was not. Her father was present for a supervised visit.
Okay. And what was your thought process?
Yeah, I wanted to honor their time together and allow them that time to be together, and I could come back the next day or another day.
Okay. So let me direct your attention to your note of 11/2, 2 days later, which is at 3795. Were you able to spend time with Maya on this day? Well, actually, let me direct your attention to the second page of the note. And at the top, in terms of interval history, you document a conversation with a social worker. How does that work at All Children's in terms of the liaison of DCF and social work?
Yeah, our social work team is the primary liaison between DCF and our hospital staff.
Did you make any recommendations to Kathy Betty of social work in terms of what Maya might need after discharge?
So oftentimes when there's a shelter of a patient, they're ready for discharge from the hospital far before the court has made a decision about what the next steps look like or where the child can go if they can go back to the home. So what we do is we provide recommendations for what those next steps should look like should they not be able to be reunified with their family. So in this case, what I was recommending was first going into some type of rehabilitation or pain management program, and then if the decision still had not been finalized by the court at that point, she would be going into a foster care setting, and there's different levels of foster care setting, and I want it to be the most appropriate level for her needs. So in this case, it was the medical foster care with the mental health component, so that they could understand her medical appointments, any potential medications, and the complexities of what was happening.
Let me direct your attention to the next note, which is at 3791. Did you attempt to meet with Maya on this date, 2 days later, for cognitive behavioral therapy? Clay, you can go to the next page at 3792.
So again, her father was present for a supervised visit.
Okay. And did you, again, just to move things along, you decided to honor their visitation time and come back another day?
Correct.
Let's turn to your next note at 11:08, which Clay will be at 3787. And were you able to provide, we'll do it at 3788, which is the page of your note. Were you able to provide some cognitive behavioral therapy with Maya in this case?
Yes.
And were you able to, would this be cognitive behavioral session number 5?
This would be number 5, correct.
So let's go to the next note, the next day on 11/9. Did you attempt to meet with Maya for cognitive behavioral therapy? Clay, it's at 3783.
Yes, I did.
Okay. And let's go to the next page, which is 3784. Per your note, were you able to provide cognitive behavioral therapy session number 6?
Yes, on 11/9.
And what types of things are you discussing during the session?
She's discussing wanting to go home. She was up all night worrying and crying about the outcome of the court hearing, and she described her pain to be a 10.
Let's talk about the next note, which is at 3780. We'll go to the second page of this. This isn't a cognitive behavioral therapy note, but it discusses some interaction that you had with risk management with Kowalski's. Is that right?
Yes.
Okay. Do you recall what the circumstance that this was?
Yes.
Okay. Why don't you tell the jury what the circumstances were at this point?
We had received a court order from the court to provide family therapy. I am not a family therapist, and on staff, none of our psychologists were family therapists. I wanted to provide the information to risk management of how to proceed, given that we did not have a psychologist on staff with family therapy experience to be able to complete this request.
And it looks like in the second paragraph you provided your cell phone number to Mr. Kowalski.
He provided his cell phone number to me. I subsequently provided the direct line to my office.
Okay. So you provided Mr. Kowalski a number that if he wanted to talk to you and contact you, he could reach out to you directly?
Yes.
Objection here. Leading.
Overruled. Let's talk about the next time that you saw Maya, which would be at note 3776. Were you able to connect with Maya for cognitive behavioral therapy on November 25th?
Yes.
Okay. And at least on the first page of the note, would this be cognitive behavioral therapy number 7?
Yes.
Okay. And again, you're reinforcing the types of activities that you would recommend for these sessions?
Correct.
Let's talk about the next attempt. Would that be on December 2nd at note 3773?
12/2, I attempted to see her.
Okay, let's go to the next page. What happened? Where was Maya?
She wasn't in her room.
Okay, where are, I don't know if you remember specifically, but for a patient like Maya, where would she be?
Yeah, there could be a couple places for physical therapy and occupational therapy. We have a gym where the kids can go to, so they're doing more activities and there's more place to be.
Objection, speculation. Overruled.
Or in the activity center, we have an additional place where our patients go, that Child Life staffs, where different activities are happening.
Okay. Let's go to the next attempt to meet with Maya for cognitive behavioral therapy, which would be at note 3769. And it looks like she, again, was, at least per your note, in physical therapy and not available. Is that right?
Yes.
Let's go to the next attempt to meet Maya, which would have been on December 14th at note 3766. And did you attempt to provide cognitive behavioral therapy again on this date?
On this day, yes, her nurse let me know that she was in the activity center, so I went down to the activity center, but she was working on a group activity with other kids and wasn't interested in speaking to me.
Okay. Do you remember what the activity was?
I do not.
Let's go to the next time you tried to meet with Maya for cognitive behavioral therapy 2 days later, and that would be at note 3763. Do you remember where Maya was?
She was not in her room. I do not know.
You note that you had a plan to discuss rewards for goals. What is that, doctor, if you could explain that to the jury?
The physical therapists were looking for ways to help engage her in physical therapy, and so oftentimes we put together a behavior chart. And we set goals. We want them to be small and achievable to start, and then those are linked to rewards. So at home, it could be things like choosing what the family has for dinner, extra time before bedtime. In the hospital setting, we're looking for what things can be reinforcers to help her to engage and feel motivated to engage in those physical therapy activities.
Let's talk about the next time you visited with Maya, which would be 4 days later at note 3758. Were you able to connect with Maya on December 20th?
Yes.
Okay, let's go to the next page. And just to speed things along, it looks like you're summarizing the rewards plan. Is that right?
That's correct.
How did she react when you discussed this potential rewards chart?
Yeah. At first, when I walked into the room, she appeared frustrated and down. But once I mentioned we'd be discussing rewards, she quickly brightened and was cooperative, outlining the list that you see here.
So talk to me about this list on potential rewards. Clay, you can scroll down a little bit. How does this list work?
So it's an opportunity for a patient or child to tell us anything that might be motivating for them. And then we take it back to the team, our child life specialists, to determine what could be feasible. Could we have someone come in and do hair and makeup or manicure or pedicure? Or could we figure out a way to do an individual tour of the helipad or have her play the piano in the lobby? What can we do? What can work?
What is a child life specialist?
A child life specialist is someone trained in normalizing the hospital experience for our patients. They're there to provide activities, talk through medical procedures, and provide support to the patient and their family.
And did all children's have people that could come into the hospital and help fulfill some of these rewards or requests of the child?
Yes. Pre-COVID, all of these things were on the table.
So let's talk a little bit about the next time you saw Maya, which would be 2 days later, 12/22/16, if we could go to note 3755. Looks like you, in the note, she gave you some more ideas for rewards. Is that right?
She did.
Well, I don't know what gelato from Pasiugo is. What is it?
I'm sorry, you don't know that. It's a gelato place that is in St. Pete and multiple places that has multiple different delicious gelatos.
Okay. Do you have a recollection of whether the hospital was able to help with that?
Yeah, I do remember Pasiugo gelato coming into the hospital for Maya.
Okay. Let's talk about the next visit on 1001-3751, please, Clay. This was the 9th cognitive behavioral therapy session that you were able to accomplish with Maya?
Yes.
And you talked to her about coping strategies as she went through her process. Is that fair?
Yes.
Not to dwell on it, but the jury knows that shortly after this, her mom passed.
Yes.
Were you able to meet and provide some bereavement services for Maya?
On the day of Maya's mother's passing, I was present at the hospital to provide support if needed. However, our chaplain went in I was not asked to go in, and then the next day I followed up with the family and Maya in her room.
Just a couple questions before I yield to Mr. Anderson or Mr. Whitney. Did Maya ever complain to you while in the hospital about any negative interactions with Kathy Beatty?
No.
In fact, did Maya ever complain to you about any concerns she had with mistreatment in the hospital?
No.
Did
please.
Okay, quick sidebar going on. This this witness seemed very believable. A couple of you mentioned she seems very well. Her personality style is a very good fit for her job. Interesting. It's because some of the testimony that's being elicited from her is trying to, I think, with Mr. Shapiro, is trying to highlight the fact that Maya was out and about in the hospital, that she was always having fun, enjoyed it there, that things were good. Every time this witness shows up at the hospital room to provide some therapy, they work with her, because she's a pediatric nurse psychologist. Oh, she's not there. She's gone. Oh, the family's here. She's down in the rec room. She's out with working occupational therapy, or I forget what it was, physical therapy. It seems like I'd a little bit be frustrated that this level of work, considering how important the hospital felt this could be for Maya, that it wasn't coordinated better, that it wasn't scheduled, that it's just, I guess I realize nurses are busy, and I'm not trying to say that nurses should do a better job of this. I'm the last person to tell a nurse what to do. What nurses do for patients is just unbelievable. I could never do it. I could never be a nurse. But it seems like this particular specialty, this witness, would be key for the hospital in treating Maya. If they believed what they say they believed about Maya, that this would be a higher priority, that this might have been maybe structured a little better. No nurse shaming. I'm not nurse shaming. Apologize. I will say we've had a lot of people in chat, and first of all, thank you. Welcome. If this is your first time or second time here, we appreciate everyone here. When it gets when chat gets nice and comfy like this with a few people in it, we just ask that we try to keep our comments as focused, as narrowly as possible about what's going on currently. Because if we try to interject a lot more, broad conversations, it can be really confusing, and chat, as you know, is moving really quickly already. So let's try to keep it as focused as we can, so we can stay relevant to the topic. When it's quieter on some court cases, when there's not as much public interest and it's quieter, we can wander in other areas, and we will on break time as well. It's nice and comfy, says Jill. Let's see. Absolutely. Most of the time, honestly says, absolutely most of the time, appointments like this are coordinated. If something is scheduled, it's always in the patient's shop, and she should have verified that prior to going to the hospital. Let's see. Anderson can be gentle and quick with this witness and still get to the important points. Edward, yes. I think if Anderson takes more than 5 minutes with this witness, no matter what he gets out of her, it will be a loss for the plaintiff. Because I think this witness, with her not having any expertise in CRPS, I think stressing that a little bit, or just hammering that point home, maybe one or two key points would be enough, and then be done. And then if the jury has anything they want to sort of hit her on, because that's what they're doing. They're these questions, some of them are hit questions, right? If the jury wants to do that, they can draw that out. But Mr. Anderson shouldn't waste his time trying to pin her into a corner, which takes. This is a chess game, right? It's not just two players, two moves back and forth. You can't do that. You need to position all your pieces before you.
Conversation's going to take me a little bit
He doesn't have time for
than
that.
just a couple of moments. So I'm going to ask you to retreat back to the room. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. We'll see you in a few minutes.
Judge says, "Okay, the jury is out of our presence." Oh, it's a proffer. We have a proffer. We're good. Proffer's coming up. So we'll get to hear this. The Zoom is a minute or so ahead.
Okay, the jury is out of our presence. Everyone can be seated. Madam Court Reporter, this is going to be designated as a proffer. Doctor, there's going to be some questions that are asked. We may or may not ask these questions in front of the jury, but for now, Mr. Anderson.
Dr. Constantine, in your records, you had put down, you had it's at
Welcome, Cheesy. Good to have you.
1001, 3817.
We're going to hear her testimony before the jury hears it. We get to repeat this if it's allowed.
You put, she denied a history of sexual abuse. Do you see that?
Yes.
She stated that one time previously a doctor had looked at her private parts but did not touch her, and it made her feel uncomfortable. You see that?
Yes.
And then she denied suicidal ideations. Upon receiving a note from this child in the context, and would you agree with me that the context you had set up was a history of sexual abuse? Would you agree that that was the first way, the lead into the next question?
I asked the question of all my patients if they've experienced abuse.
Right. And immediately after that, a 10-year-old girl says, one time previously, a doctor looked at her private parts but did not touch her, and it made her feel uncomfortable. You see that?
Yes.
What is repression or suppression of sexual incident in children? What do they do if they have something bad happen to them sexually that they don't understand?
In some cases, when a child has experienced a sexual assault, they may not remember it at that time. In this case, what I saw here, when my discussions with Maya, where she said she had previously at another organization had a doctor look at her private parts, but it was part of a medical examination and that individual did not touch her.
Well, doctor, would you agree with me that a 10-year-old child, or perhaps even younger child, may not know exactly what constitutes sexual assault or sexual battery?
In this situation, a physician looking at the private parts of a patient would be part of a typical medical examination.
Then, and are you aware of the prior proffer of Maya Kowalski in this case?
No.
All right. Well,
I don't know. I don't know what you're speaking of.
Sure. Well, Maya Kowalski, your patient that you were describing here, if it was such that Maya Kowalski actually had a physician come in, a male physician, described specifically by height, weight, what the physician had on, a name tag, everything else, who came through the door and said, and walked up to her without a chaperone saying, "Can I take a peek?" And then went and pulled her drawstrings down below her vagina, pulled her panties down below her vagina, and stared at her vagina for a period of time long enough for the child to feel uncomfortable, and then turned around and left saying, "Thanks." Would that be the type of information that you would find necessary to report?
That was not what was reported to me.
I'm not asking you that, ma'am. I'm asking you if that set of facts came to your attention, would that be something you would have to report?
If there was a hypothetical situation where a patient presented to me a concern where any team member in our organization made them feel uncomfortable, outside of typical medical care, because sometimes medical care is uncomfortable, then I would talk to our risk management team, and if it met the statutes for potential abuse, neglect, abandonment per the Florida statutes for a report to DCF, I would make a report.
Well, you don't necessarily have to have risk management to do that. You are a licensed reporter you would have to report no matter what risk management said. Isn't that true?
If it met the criteria for abuse, neglect, or abandonment.
In this, you say, Maya told you, she stated, one time previously, a doctor looked at her private parts. She did not say a doctor at another hospital, did she?
She said previously, which meant for me at a different organization.
She had been at Johns Hopkins now for over, what, 10 days? Right. Did you know of any other organizations or hospitals she had been at?
Yes.
All right. How did you distinguish then between all of the doctors that had come and gone in Maya's life from the time she came in on the 7th, or even previously visits at Johns Hopkins from non-Johns Hopkins doctors?
I utilized the word previously in my note because it meant at a previous organization.
And why would it matter where it was if the child's comment there let you know someone stared at her privates and made her feel uncomfortable?
It would be for comprehensiveness of my documentation.
Well, it wouldn't really matter, though, would it? It doesn't matter whether it's a Johns Hopkins doctor or if it's a doctor from down the street or anyone. That's still a reportable offense, is it not?
This is not a reportable offense.
But the point is, you didn't follow up to find out if it was, did you?
This is not a reportable offense. This was part of typical medical care. There was no abuse, neglect, or abandonment.
How could you possibly know what was going on in that child's mind based on just that statement?
I asked her the questions. She told me that she felt uncomfortable and that she was not touched.
And 10-year-olds don't even really know what sexual abuse is in many instances. True?
In many cases, 10-year-olds do know what that is and are openly reporting it.
Yes, but in many cases they do not.
In some cases, I cannot speak to this situation. I wrote down what she reported to me.
Particularly in an instance where a child is being held, let's say, at a hospital, and a lot of doctors come and go in there. That child may not know what's appropriate and what isn't appropriate. Correct?
Each situation would vary. She had been to a number of hospitals and organizations.
If this was not a reportable offense, tell us the specific date, time, and circumstances of this encounter between Maya and a doctor.
I do not know, previous to her hospitalization with us.
You're a licensed reporter, are you not?
Everyone in the state of Florida over the age of 18 is a mandated reporter.
Sorry, excuse me.
Let me stop you. Can you relate to me your encounter with Maya Kowalski about this incident?
What I have written here is what I recall from that.
Well, did you follow up with questions about the incident, or it's just she made the statement and then you moved on?
Well, this would have been a summary of my discussion with her. So I would have asked, were you touched? Did that physician touch you? No.
So I'm trying to ask you to relay, as best as you can remember, your discussion with Maya Kowalski that generated this note.
Mm-hmm. So in my discussion with her, I would have asked about potential sexual abuse in the past. Back and forth in our conversation, she declined that happened. She described a situation at a previous organization where a doctor had looked at her private parts during a medical exam and that she was not touched.
And the conclusion that it was a previous organization, is that what Maya said, or is that a conclusion you drew?
I utilized the word previously, which would have been that she told me it happened at another organization.
Okay, so she didn't say it was another organization, she just said previously.
Not here.
Did she say not here?
I have previously, which means to me it meant not at Johns Hopkins All Children's.
You can continue, Mr. Anderson.
Isn't it true that previously that term could mean the day before, or it could have meant the month before?
I would have considered it all to be in the context of the current hospitalization.
I'm not asking you that now. I'm just asking you as a matter of the English language, the term previously could have been from the day before or a month before. True?
Previously means prior to that time.
And prior to that time, for the 10 days before, where had Maya been?
She was at the hospital.
And all the doctors that she saw would be at that hospital, right?
Yes. Well, not necessarily. They may have medical staff privileges, but they may not be employed by the hospital.
The vast majority of
the
them
majority.
would be Johns Hopkins doctors. And yet, with that knowledge, you still did not pursue with this child any further details, did you?
This description that she provided would be similar to what we call a Tanner staging. So a physician between the ages, for a child between the ages of 8 to 10, would be looking at puberty, they would be looking at pubic hair development, breast bud formation. So my understanding was this was part of a typical medical examination in which a Tanner staging was being completed.
You were aware that Maya had not reached puberty at this point, were you not?
I'm not a medical doctor. I wouldn't be looking into that.
You didn't know, as you talked to this young girl, whether or not she'd reached puberty?
I hadn't asked her about menses.
And isn't it hospital policy? Is it in fact most hospital policies? Isn't it in fact most every doctor's hospital policy that when you go in to see a young female child, if you're a male, you have a nurse or other chaperone?
I can't speak to the policies of all those organizations.
Is that not the policy at Johns Hopkins?
It is not part of my standard practice, and I am not aware of the policy specifically because I do not do that.
You're female. I'm talking about male doctors.
Subject to the lack of foundation.
Right? Male doctors going in to see a female, especially a young female patient, especially when there's going to be disrobing involved, have some female proctor or whatever you want to call it, nurse, observer. True?
I can't speak to that. That's not my practice.
Did you see in any of Maya's records a doctor write the term, what was it, Tanner?
Tanner stage.
Tanner stage?
I do not recall. I have not reviewed every single record.
Did you look?
No.
Isn't it true that it could have been just as easily another doctor at that hospital who had come in and disrobed exactly the way Maya Kowalski previously testified?
I utilized the word previously, which meant prior to the current hospitalization.
Based on your opinion of the term?
Based upon what I reported in my note here.
Does the defense wish to have any questions for purposes of proffer?
Yeah, sure. Dr. Katzenstein, we're talking about your use of the word previously. Not what it means generically. Is what you're telling this court, when you put down the word previously, you meant that specifically to signify that whatever was being described did not happen at All Children's.
They need
Correct.
to do a
It meant
word
previous
search
to
on
the
her
hospitalization.
records now.
And what was described to you, what you wrote that day, was based on your conversation with Maya that day.
Correct.
Quick word search.
Nothing in your note
This
is
doctor's
quotations.
notes. Where
There
else
are no
has she
quotes
used
in that note.
previously?
Doctor, can I have you step outside for a few minutes?
Sure.
So we're trying to see if
The doctor's outside
they
of our
open the door here.
presence.
Let's see.
We're here on the objection to the question having to do with did she report any abuse while at the hospital or something along those lines?
I think it was more broad than that, Your Honor. I'd have to have the court reporter read it back, but it was just, did anybody tell you anything?
Any complaints?
Any complaints about Maya?
Any prior mistreatment was the phrase.
Okay, whatever it was in follow-up to merely just establishing Her interactions with Kathy Betty, the social worker, from her perspective, were fine, and she didn't hear any complaints regarding Maya's treatment. That's all it was meant to do. It's not meant to open this door wide open. And I don't think the jury got any impression about anything related to that. I apologize if this cracked the door on this. I had no idea that this was going to lead to this, but certainly in open court, it's important for the organization to hear from Dr. Katzenstein. I'm sure he was going to proffer her what she said.
Your Honor, this jury, it takes extraordinary levels of notes. They are on to everything happening here. The jury has now been led by counsel's intentional questions to a conclusion that nothing involving any type of assault, any type of, what was the term again, mistreatment occurred at this hospital when there has been clear evidence in a proffer of something and other evidence, in court, evidence of what Kathy Beatty had done. But the problem here is the question wasn't limited to Kathy Beatty. This was an open-ended question in which the witness, and if I'm given a moment, I believe I can find the actual Florida statute, criminal statute, about this behavior as sexual assault. This describes an act of sexual assault if it was even the slightest follow-up to it. And with all due respect to the doctor, the term previously does not give license to all of the conclusions that the witness brought to bear. As a licensed reporter, she was absolutely obligated under these circumstances to explore this and to see what would happen to this little girl, and she did not. Then, capitalizing, I guess, on this, the defense now has this witness testify that nothing of the sort happened, leaving the plaintiffs with the dilemma of how are we going to go and cross on an extremely important point without getting over into an area that so far has been excluded. This puts the plaintiff at a great, great disadvantage in this case, because now it makes it sound like there's an issue of fact here about whether or not Maya was telling the truth on any of it. And so we would move the court to reconsider the whole issue as to the sexual molestation of Maya Kowalski, at least insofar at this point of being able to ask the same questions of this witness before the jury that we ask in proper, and the court asks in proper. And I think that is the only fair way to resolve this. I see no way an instruction could clear this up for us. I just don't.
If you need a response, the jury knows nothing about this. I don't.
That's the point.
How could a generic question about did you, whatever it was, see any untoward conduct about Maya, anywhere close to suggesting to the jury about alleged sexual abuse, non-sexual abuse? It was a generic question about just her general observations. It was not meant to drill down and try to prove or disprove
Mr. Hunter is not
happy. A collateral lawsuit. I mean, we're doing our best to toe the line. I didn't show the note. There was nothing intentional about this. There was no emphasis to this question. I just strongly disagree that somehow a question that at best was mildly inadvertent in attempting to capture this somehow poisoned this jury with the impression that Dr. Katzenstein, razor right-handed, is attesting that she reviewed the hospital record from A to Z and never saw anything untoward.
Here's where I'm at. I think I asked 2 or 3 questions. Yeah. In that 2 or 3 questions, I was able to deduce that she wrote the word previous. She made an assumption that it was at a previous organization. She didn't ask any follow-ups. And she, being this doctor, didn't, and perhaps in her mind she just assumed it was this, whatever, the 10 or whatever. But it didn't sound like she made any sort of follow-up question as it, did this occur here? She just made a conclusion that it was previous. And I got that in 2 or 3 questions. I'm talking now. So the question you asked was something along the lines of whether Maya had relayed any abuse to Dr. Katzenstein. And I don't think the word abuse, what was the word?
Mistreatment.
Had she reported any concerns of mistreatment was the term.
So it seems that the answer no gives the impression to the jury that Maya did not relay any impressions of mistreatment, which probably isn't the correct case, isn't the correct answer. If the assumption is that, or if the assumption is Maya's disclosure was talking about something that was occurring at Johns Hopkins Children's Hospital, and what day did this occur? 10 days after admission?
It was the 12th, I believe. 17th? Sorry, I keep thinking.
So now I'm in a pickle because the defense did not want to get into this issue. I excluded this issue, and now you're asking a question that gives the witness the opportunity to give the impression that Maya didn't say anything.
May I call her back and proffer to clarify this? Because
I asked a couple of questions on that specific issue.
But her testimony is going to be that if Maya had told her that that happened at this hospital, she would have investigated it further. And the reason why she didn't do a further investigation, because it was very clear to her in talking to Maya that what Maya was reporting was something happened at a previous organization. I apologize if that was
we have done the proffer at this point in time.
He's going to allow it. Look at that.
What should I do at this point, folks?
Oh my goodness. He would, right now, I think the judge would accept a call for mistrial from the plaintiff.
Judge,
it's Mr. Shapiro.
Yeah.
One horse, one rider.
I truly believe in my heart there's no way this jury heard that question and thought that there was any implication. I was trying to narrow it to this witness. If it would, I don't want it to happen because it would seem to imply that there's something greater, but I guess the cure to this would be as if Your Honor would tell the jury to disregard the last question and answer, which would be very damaging to the defense.
Well, the jury knows nothing about the alleged sexual assault because I've kept that out.
Right. So,
at your request.
Right, I understand. I guess the cure would be to just tell the jury to disregard the last question about I'd have to talk with my defense team. That would seem highly prejudicial, but I guess that would be the cure, but I'd have to talk to them. It's fine. Yeah. Okay, then we would still
I'll take 5 minutes. We'll be back in 5 minutes, and hopefully they'll have an idea as to how you want to proceed.
This is huge.
All rise.
This is
Closing
huge.
recess.
Mr. Hunter is shaking his head in disbelief. He's thrown his hands up. He's like, "We've lost. It's over. If this comes in, it's over." This is massive. Okay, let me. Oh my goodness, I'm trying to wrap my head around what just happened here. This has been excluded. This major allegation has been excluded. The judge has said this cannot come in. This is we can't do it. And we've danced around this issue. We've had proffers. We've had Maya testifying. We've heard this, and the judge has said we can't allow this in. We're going to keep this separate. And defense, in one question, asked, "Did Maya ever report any mistreatment at the hospital?" The answer was no, but in truth, she did. She did report it, and according to Maya, she reported that it happened at that hospital. Now, it put together another piece. If we go back to this witness's testimony, this Dr. Kastenstein, she says, I was, in her role, she's helping Maya complete her journals. She's helping her do entries. The journal is all about her hospital experience. Everything she's doing is there to help the hospital experience, to help her through her therapies, to help her normalize the situation in the hospital. And she's saying, has this ever happened? And in this scenario where they're talking about, all the nurses I like, and these are the things I like, and I like the view of the ocean, and, I like eating the chocolate cake, and things I don't like, well, this one doctor, right? Am I wrong there? Is this not happening in that same environment, in that type of scenario? Yes, Mr. Shapiro messed up. Okay, he should have known that this question got too close to a line, to something that he did not want brought in. And we've, unfortunately, for poor Mr. Shapiro, I love him, by the way, an incredible attorney, very smart, very, he's a bulldog. He's great. He stepped in it, and he's stepped in it before. The number of times he's apologized to the court and said, "I'm sorry, Your Honor, I didn't mean to." This is another one. And Mr. Hunter won't even make eye contact with him. Is just staring straight forward down to the desk, throwing his hands up. He's like, we screwed it. It's over. Wow. So judge is taking 5 minutes. Judge is taking 5 minutes to think this over. But as long as his mindset doesn't shift, I think what we're going to see from the judge is he's going to allow what we just saw in proffer. And that the whole idea of a proffer is to say, stop, jury, you leave for a second. We're going to continue as if you were here, right? We're going to ask you the questions and hear what the answers are. But it's such a gray area. It's such a sensitive area. These answers that you're going to give are so sensitive. We have to make sure the answers won't cause problems. The proffer is complete. It does cause problems for one side, but they say, now that we know what the answers are, we're going to bring the jury back. And it sounds like the judge may say, Mr. Anderson, your witness, proceed. And he gets to walk through the same questions we heard with this witness in proffer, which is huge. It's a bomb will go off in the heads of the jury as they hear this, because they have had no inclination at all that this is what happened. Everything to this point has been medical malpractice. Are they treating her for the right illness? Are they diagnosing the right illness? How are they interacting? What's the interaction with the family as far as, separating Maya and everything? This is completely new. This blows the doors wide open if it comes in. And the judge has to weigh this. And of course, he has to say, what's the implication if I let this in on the other side? Does this, he's letting it in after the plaintiff is done. They don't have time. Their case has been rested, and he's letting it in now. If that's his decision, and I think he's leaning that way. The way he looked at Mr. Anderson was just like, it's coming in type thing. That's my gut feel. I may be wrong. I've been wrong many times before. Somebody was asking about the time that each side has, and I'll go over that quickly. That initially they had 55 hours each, and that's time arguing, directly questioning witnesses or cross-examining a witness in court. And when there's a depot, they split up who gets what time out of the depot. And the time that the jury asks questions is split between the two sides. So they had 55 hours. The judge granted an additional 4 hours per side, which, as of this morning, the defense had 34 hours and 10 minutes left. The plaintiff had 9 hours and 30 minutes left. I can pretty safely say I think they've burned at least half an hour at this point. The plaintiff has burned at least half an hour, so we're right around the 9 hour mark for them. I don't have a timer, and obviously I don't know when the judge starts the stopwatch and stops it. We'll have to wait for the shot clock information tonight to see that. But man, if this comes in, they both get more time. I think. How do they do that? How do they go back and say we're going to reopen the plaintiff's case? Talk about highly unusual. Reopen the plaintiff's case and allow this huge thing in. The judge had ruled previously that this is something that, you need to file a police report, and this is a separate trial for. And now if this comes in, I don't know. He's trying to figure out something. He's asked for the help. He was so curious about, exactly what had happened here that he interrupted the proffer to ask the questions himself of the witness. And you saw the conclusions he came to. He's like, I don't know. I think you asked a question that solicited an answer that leaves the jury with the impression that something happened or something didn't happen when it did. So obviously the plaintiff is not going to be moving for a mistrial at this moment. But I think honestly the judge would consider that if they did, but he won't. Let's see. Pauline says he won't let this in. Rob would be going crazy over that comment. He probably is. Couldn't Anderson do it on rebuttal? I don't know. I'd have to defer to a legal minds as far as rebuttal. Usually rebuttal is it's commonly expert witness that's brought in to counter the expert witness the other side had. That's usually what we see. And we just lost camera feed. No, it's back. We're good. Skybell says the defense opened the door. The judge went to call his wife. Wife, I need some help. No, I don't know. He's shaking his head back there. And maybe he's got a pillow he yells into or something, because so many times he's been frustrated where he has walked a line. He's walked a line throughout the trial and tried, even where the line didn't exist. He has to draw the line. He says, I've drawn the line. And here this suddenly forces his hand, possibly. Katie Seller says, Recovery Addict, not sure if you saw my question. What if she realizes her answers were terrible and changes her responses between the proffer? That would be very, very bad. That would be very bad. And I think she would be called out for that. Surely she should report even if it was a different hospital. That's what the judge was getting at. It's like, and Mr. Anderson as well. I said, hang on, there's nothing in the notes about a Tanner, what is it called? A Tanner, that's the term for the sort of examination where you check on the puberty status, development. But there's nothing there. There's nothing there.
So is the doctor. Okay. Any further thoughts?
We're in black
yes,
right now. Hang on.
The question we had the court reporter marked was, did Maya Kowalski communicate to you any concerns of mistreatment in the hospital? Again, I had no intention of implying anything other than the course of action regarding her therapy sessions.
The cameras are cutting
what she
out.
observed. I did not mean to open the door to this whatsoever. I do not believe anything about that question would bring or allow this court to be derailed into a new cause of action. If the court wants to bring
none of the feeds have
corrective
video
action,
right now.
they can ask the jury to disregard the last question and answer, which obviously would be some prejudice to the defense, but we would accept that.
Well, the plaintiffs move the court to, again, we believe the defense should be allowed to finish their questioning, but that the plaintiffs during cross-examination be allowed to follow up on the denial of Maya stating anything having to do with mistreatment in the hospital as no, and further cross-examination as it leads up to and includes whether there were any claims by Maya Kowalski, as set forth in her records, that someone had done this, that someone had peaked, that someone had done these things. And we should be allowed, based on the proffer of Maya Kowalski, to explore the specifics of what Dr. Henschke documented in her records, and we believe either should have been were known to this witness and simply not put down, or never explored. And the problem we've got here is the jury now hears from the one person out of everybody that was available to Maya at this point, because she couldn't see her mom, she didn't trust PD. So now we've got the psychotherapist here that she's seeing regularly. And the one person that she would be more likely than not, Judge, to report something to is saying, no, she never said anything to me. And that inference drawn from that is far-reaching in these circumstances, because they've already heard Dr. Henschke testify about how Maya would open up to a female therapist. Now we've got Dr. Kastenstein putting us in a real box here, and I see no other way than to be able to explore the full circumstances of what happened with that notation she put in her records. Elsewise, I need to be able to ask, well, did she report to you about Kathy Beatty doing this, doing this, doing this? Did she tell you about another doctor? Exactly what I asked there. I'm not going to say, depending on the answer, though, I should be able to go fairly far into the specifics of the facts as testified to by Maya in order to test the witness's knowledge of these things. And that is the only way that we would be allowed to correct this wrong. This is a seminal issue in this case.
I will say that the suggestion that we start talking about the alleged sexual abuse is an invitation to do this entire trial again. Full stop.
I understand.
That has either a mistrial or a reversal written all over it. I go back to the issue of the alleged sexual abuse was not in the pleadings. It was not disclosed to the court prior to us seating the jury. We did not discuss the questions we ordinarily would have asked with respect to sexual assault with this jury. So I've got no way of knowing whether I would have had any cause challenges with any of our seated jurors or alternates as to whether or not they would still be on this jury. Now, I agree that there is an impression that the question asked that is detrimental to the plaintiff. I think the only cure that I can do at this point is the statement that Mr. Shapiro was saying is I would instruct the jury to disregard the question and answer as to whether Maya Kowalski disclosed any mistreatment in the hospital to this witness.
And I'm going to have to tell the jury to disregard that. And I'm assuming, Mr. Shapiro, you're not going to follow up on that issue.
No, not on that question, Your Honor.
Your Honor, we have... Since I am doing a curative instruction, there's no reason for the plaintiffs to drill down that issue in front of the jury.
No.
This is going to be tough, but we would ask the court not only to instruct the jury to instruct the jury to disregard the question and answer, but they are to draw no inferences from having heard the question and answer.
That's not it. That's not it.
I think
Goodman,
the instruction the court
Goodman Law
directs
had it right.
The jury to disregard the question and answer as to whether Maya Kowalski disclosed any mistreatment in the hospital. I think that is sufficient. I don't think I need to go any further than that. So that's what I'm going to do. Now, we only have 5 minutes before. How much longer did you have in your...
Two
questions?
Minutes, Your Honor. I can finish my direct.
Okay. So why don't we finish the direct, and I'll send the jury to lunch. Let's go get Dr. Katz's.
The plaintiff does not want a mistrial. Hey, there's Jules there and back. Second row. Just going off camera now. This is frustrating. A lifeline thrown to the defense. He's going to be extremely careful to not go anywhere near
with
this.
Us. When I bring the jury back in, I'm going to tell them to disregard the question and answer as to whether Maya Kowalski disclosed any mistreatment in the hospital, and then we're not going to follow up on that issue in front of the jury. So we're not going to talk about it. Okay. Okay. Let's bring in the jury.
I know a lot of you are saying the judge is wrong, but the judge is right that bringing that in now would end this trial at this point or cause a reversal. The problems with it not being pled, he listed that. The problem with the jurors not being questioned on this to see if there were any things that would cause for dismissal. He just can't go there. He just can't go there. I was wondering if they would allow a more restricted summary where they said she did reply, where they said something to the effect of,
jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, did no investigation, received no information. Is that all correct? And you have not been approached about this case. Is that correct? And you've seen no media coverage. Is that correct? Okay, members of the jury, I'm going to instruct you to disregard the question and answer you heard last, which was whether Maya Kowalski disclosed any mistreatment in the hospital. So you are to disregard that question and the answer. You may continue, Mr. Shapiro.
Thank you, Your Honor. So just to recap, it sounds like the last time that you saw Maya in the hospital was for some bereavement counseling, I think, on January 9th. Is that right?
Yes.
Okay. And then just to orient you, Maya was discharged shortly after that. Did you have a chance to see Maya after discharge?
It wouldn't be my practice to follow up after discharge.
Okay, and why?
Because I don't follow patients typically outpatient for therapy unless they're following up with me for a full neuropsychological evaluation, which she was not.
Okay. That's all the questions I have at this time, Your Honor, and thank you, Doctor, for your time.
Thank you.
And members of the jury, since you have been sitting there for so long, it's actually time for lunch. And I would normally say, let's go forward, but I actually have a meeting that starts in 6 minutes. So the reason that we can't proceed is because I've got a meeting. So I apologize. So we're going to pick this up, have them ready to go at 1:30. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And enjoy your lunch.
All right, this is
All rise. Jurors exit.
This is crazy. I think the judge meeting, that's a hard stop. So I don't think we've got time to go into anything right now. So I think the judge is going to say we'll see at 1:15? Is that what he says? So we still have cross of this witness. jury questions.
The jury is out of our presence. Doctor, you're in the middle of your testimony, so you can't talk about your testimony with anyone, including the lawyers, okay? We'll be back at 1:15, unless you think we need more than 15 minutes.
No, Judge, I would, I'm sorry.
I am going to try to make some statements about the DV motion, so that's coming.
Oh, wow. That's going to be huge after lunch.
I would ask for the plaintiff is we do intend to play Dr. Hannah soon, if not tomorrow. I don't know if we're going to get any cross designations of his testimony, but if they don't plan to cross designate, that's fine. We filed our designations some time ago.
If you want to
I'm
sorry, should I just go with
Yeah, you can, or you can keep waiting if you want. You're free to go.
Thank you.
Let us check on that, Judge. I would be surprised if we didn't.
We will be back at 1:15. You can tell Mr. Elegant and Mr. Altenburn that I'm going to try to make some rulings on DVs at that time. Okay, thank you very much. We'll be in recess till 1:15.
Okay, so we've got till 1:15. All right, the DVs that he's talking about, these directed verdicts. This is where the defense has asked that the judge rule and exclude certain allegations from the trial because of, no evidence has been presented. They might be duplicative. They've got all these different reasons. But those we are waiting on a handful of those from coming back in. Oh my goodness. Fun stuff. All right. I don't know. I'm like on the edge of my seat. First of all, I thought the judge was going to bring this in. He was going to allow it, at least in part, where she was able to answer partially. But the more I think about that, she couldn't, because previously could mean a prior hospital and it could mean the current hospital. So if they brought it in part, there's no way to bring it in a little bit. It would have to be all the way fleshed out. So I guess the judge did the right thing if the plaintiff's goal is to continue to a jury verdict, which I believe it is. I don't think the plaintiff really wants a mistrial at all, because that is so expensive. They've fought so hard to get this to trial. If their goal is to get this to go forward, they can't have their cake and eat it too. They can't have this part in. They can't have the alleged essay in at all if they want to go to verdict. So I think the judge made a good call on that one. Although there may be a separate case. There may be I don't think there's any statute of limitations. There may be a police report filed, some investigation done, and a separate trial involving that. I don't know if that would fall under double jeopardy, or I think it's separate enough that I think it would work. Savas Gunn gifted 5 memberships. Thank you very much. I appreciate. We've got so many new members here. I appreciate that. All the new subscribers as well. You guys are amazing. Welcome to, whether you're coming from Rob from Law and Lumber or from another place. Welcome. It's good to have you here. This is a fun community. I appreciate you helping make this a place where we can enjoy watching trials together, and sort of like I wouldn't say it's a safe environment, because we spend all day talking about murder and the worst of society, right? So it's not really a safe and comfortable environment, but we do try to treat it as a very respectful one. So we're respectful of all the people who are both in chat as well as here on the in court. So can Mr. Anderson simply ask where Maya Wire happened? Barbara, yes, he did. That actually was done in a proffer before the court, and Maya said it happened at Johns Hopkins. But I believe, to my knowledge, there has not been a police report filed on that yet. And I think they will probably wait till after this case to file that, and then they would. We've got Corey, member for 6 months, riveting trial. Thanks for the coverage, RA. Thank you, mods, and welcome to the new members. Thank you, Corey. Good to see that yellow courthouse by your name. Crazy morning in court. We've got exciting stuff this afternoon as well. We only have an hour and 15 minutes, which means we have 1 hour. We'll come back 15 minutes early just to get set up and ready for the testimony that's going to happen today. A couple of you asked, some of the new people, they asked the background of my story as far as my channel name, and the question if I'm a lawyer like Rob and the other people on LawTube. I'll answer the second one first because it's very easy. No, I'm not a lawyer. I am a true crime fan. I've loved the law since I was a kid, but my expertise is in technology, I worked in the federal government in top secret stuff, fun stuff. So I worked in IT. I do have I've done a lot of camera work. I've worked with police departments. I've filmed for police departments, metal detected for them, flown drones for them. Been through like Citizens Police Academy stuff where you get to get tased and beat up police officers in red men suits and get bit by the dog and get shot at by people with airsoft rifles. It's a good time. I love many aspects of the law. About my channel, however, I initially built this channel years ago to share my love of metal detecting. And I named the channel Recovery Addict because I was addicted to recovering artifacts from the ground. And I thought it was a catchy little name. And that still applies. I still love metal detecting, and occasionally I'll share something metal detecting related on here. But that's my hobby side. I personally have my own story involving addiction that's a little different than many others, because my addiction was to computer gaming. It nearly destroyed everything that I hold dear. Nearly lost everything, and so yes, I'm in a recovery for that, and I'm grateful for the opportunity to get another chance at life, basically, when I just about threw everything away. So we do support all those who are working on their path to sobriety, wherever they may be at, whether it's day 1 or day 100 or day 1000, or anywhere along there. So wonderful having you guys here. Thank you. Wasn't the essay brought up by the plaintiff well into the trial and had to be separate? Yes, it has to be separate. The judge says we can't, because it would. Primarily, I think the biggest issue is not that it wasn't pled. Okay, if that was the only issue, that it wasn't pled in the original allegations that there was this incident of SA at the hospital, right now it would have been coming in right now. Assuming they had questioned the jury on this topic beforehand. If the jury had been questioned properly on this topic and vetted for this, it would be coming in right now. Let's see. Software engineer, so I'm in IT. Did you ever code? Very little coding. I coded on, there used to be like a Palm Pilot type thing that it was like a hinged computer. It used Opal. I've done Opal. Before that, I think BASIC was the last program I wrote in. It's been a long time. Let's see. JM, hello, welcome. Good to have you here. Glad to have everyone here that's visiting and found us through Rob from Law and Lumber. He's an amazing lawyer. I love his takes. I am not in any way competition for him because he provides a legal analysis and insight that can only come from an experienced trial lawyer. And that's what you get there. On my side, I provide the technology and the audio. I run a stream, as you can see here. I've got 4 or 5 different streams going that I'm tracking. I improve audio. I'll bring you multiple angles if those are available, so you can watch multiple things at the same time. Like one of the things I'm watching is the Zoom feed. So when the court feed from the courtroom doesn't broadcast everything that is open to the public, which happens often, I'm able to read those over to you. By rule, I can't let you listen to it directly. I have to restate what I hear. That's why when I hold my phone to the ear and tell you what I'm hearing, that's what I'm doing there. And I can't show you that video either. But we have to follow the rules to play by the court's rules, and that's what we're doing. Stacy, thanks for the kind words. Thank you very much. I'm glad that you're here. Thanks for joining us. Lots of people with similar comments. Thank you. Seems like the defense is trying to get a mistrial. I think they would love a recrack at this. They would love to do a redo. I'm not sure if anything can go as badly as it's gone for them in this trial. Now they've won a couple good things. They've won a few points in the DVs. They've had some things thrown out that weren't included. But if they get a redo, guess what happens? You get to refile. You get to refile that complaint, and it's going to be amended complaint number 9, and they're going to fix the problems that got the first ones thrown out. So they're going to say, oh, and by the way, we're going to include that SA in there. We're going to just tack that right on. Okay, that's what's hanging out there for the defense. If they ask for a mistrial, they're like, all right, we'll start over, we'll reset, but then the plaintiff is going to include that allegation of SA, and that's coming in. So. Devin Daughtry, welcome to the gallery. Love to see that blue courthouse change of color by your name. Thank you for your continued support. For the hospital, it's about money. Well, it is a lot of money. It is about money, but it's about their image as well. It's interesting to think that I saw a tweet. I'm not sure who said it, or maybe it was actually was it Melanie who said this? Melanie Little, that said that the attorneys Shapiro and Hunter were involved in this case and in meetings while Maya was in custody. at the hospital. So that's how long they've been involved in this, that they've been involved. They're the hospital attorneys, and they've been involved since that time. And I think we even saw some court records about a meeting that Mr. Shapiro was present at, and it's way back in the treatment time. We need to keep RA here and not behind the cameras in the courtrooms. I think there will be some trials where we will be the camera in the courtroom. We're setting up for that. So, what did Shapiro's question accomplish for the defense? The question that got thrown out was basically, did Maya at any time complain of any mistreatment at the hospital? And she said no. Well, according to the witness's understanding of the witness's notes, which that's all the witness can remember. The witness can't remember anything else. It's just whatever's in the notes, that's what it is. And based on what I wrote there, I think I meant that was at a previous hospital, previous to this stay. Then, if that's true, then the witness is not committing perjury. It's not lying. But if it's not true, we have a problem. We have a problem. The correction the judge issued for that, by the way, was quite interesting, saying that we're just going to instruct the jury, the curative instruction, just to forget that thing you heard last, where Maya never complained. Now, I do think that retracting that, unringing that bell, does more good for the plaintiff than initially I thought. The way the judge worded that, it really made it look like, hey, something was wrong there. Something happened wrong outside of your presence. We can't tell you what it is, but there was a question that was asked, and there was an answer that was given. The answer was no, because the jury heard the answer. But there's something that happened there that was wrong, and we have to strike that from your memory. You have to not consider that, which then your mind would naturally say, then maybe there was something that Maya complained about. Now, they have no clue of the nature of what the complaint was, and they're probably thinking it was something related to, the battery that they've heard about, the alleged the abuse, the separation, how the family was treated. Yeah. Oh man. Jess, I've heard that as well. I would love to work with. This is my dream job. Is to get feeds available for people so they can watch court. So yes, that's something we're actively working on. But I haven't reached out to Emily D. Baker. I know she's working on feeds that way. But I'd love to look into that. It's not evidence. Yeah, man. Just this is a great day. I cannot wait to hear Rob's take on this when he tears this down and breaks it down. I'm sure Melanie Little will have something to say about this one as well. I know tomorrow night, we have our very own friend, Dr. G Explains. He's a clinical and forensic psychologist who's going to be here on the channel with us. Right after court ends, we'll take a brief break, and then we're going to come back with a live. We're going to tear down and get his analysis of two witnesses, Sally Smith and Catherine Beatty. We're going to do those together live. He'll be here. He'll be answering your questions as well. So if you'd like to watch that would be great. I'm so excited to have him be looking into this case. This is one he sort of put on the hold and wasn't going to get into initially, but he said, I'd really like to look into these witnesses, and he offered to come on the show and do it here. So I'm super excited. Dr. G is fantastic. Every time he's been on the show, it's been wonderful. It's just a stellar individual, a good friend as well. Tony Schaefer says, I made it. Love you in this group. Tony, welcome. You did make it. We're just wrapping up for lunch. We've got just a few minutes. My little box down at the bottom is not showing. Oh, man. I get so carried away. Here, I'll put it in the big box. There, we're good. Now I've got the objections showing as well. Oh, let's do that before we wrap up. Let me show you the objections. Give me just a second to put it together. Box source 2 is going to be 4. Let's cut to super source. There we go. Okay, so objections. Man, it's too many buttons here. My mind is just going. That's what it is. Why are we not getting on air? Okay, here we go. I have to be on camera 1. It does not want to, there it is. There's our objections. If we look at our objection count, I'm sorry, I'm just lost on this one. We were up to 1290 or 1229, which means we've only got a few. I think we're right in between. Let's see, Trin Nurse and Kathy. Well, Kathy's I think our winner right now as far as the lead, and Blackbird Squeaks 1231. That's where we are on the objections. So, all right, let's. No, Jenny and Gia. I cover almost always murder trials. We try to stay away from ones that involve children generally, but occasionally we do. Are we still working on the Vallow, Arizona case? Yes, that's still one we're looking into. Other cases we're looking into, Sarah Boone, slated for the end of this year. BK, which is going to happen probably in more than a year. We've got a couple that are... The only one I know I'm not looking into is Delphi. And that's got bizarre. That is a circus right now. Please see my tweet about her wording previously. It took me ages to find. I missed it. The chat is going so fast. I'm sorry. Did proffer count against time? KJAB, I don't know. The judge has not come out and said that proffers count against time. It is a request from one of the parties, but also a proffer is like an expanded version of judge may we approach, right? So they do that because they say we're about to go into a question, or we think we're in an area where it might cause problems for the trial. So if we approach, we can get this sorted out before we step in it, really. And the judge just said, approach all you want. Request, I'll grant it. You can come up here, we'll talk it over. I don't want this to get, thrown off the rails by some stray question. And a proffer is like that, where they say, okay, this time we're going to have the jury leave, but we need the witness here because what's coming next, we need their answer to listen to, and the judge is going to rule. So I don't think proffers count against the time, but we'll see. We'll see. The judge might clarify that. Let's see. Proffers to print testimony without the jury for the judge to decide if it's admissible. BK's going to be back in court many times. There are going to be hearings upon hearings upon hearings. I think where I need to check and see if there's anything new, but where we're at right now is we're waiting for the judge in that case to rule on cameras in the courtroom for the trial, the ongoing trial. And we're getting some rulings about individual hearings, about whether cameras are allowed and whether it's, tape delayed or anything else. But we're waiting for the big ruling on the entire trial. And if the answer is yes, cameras are involved, allowed, then I will be there for that one. I'll be in Idaho for that. Okay, any other questions we have to answer right now before we go to break? Ruby, Frankie, Alyssa, I really think this case is not going to allow cameras in that trial. If you think about it, we've got child victims, living child victims who are going to be testifying. It's the case is full of harm to a child. I don't see how the judge will allow that to be televised. So I mean, it will be covered. Media will be there, but I don't think it'll be cameras in the courtroom. Even though that there are cameras in the courtroom in the preliminary hearings, I think they'll be excluded for the trial. That's my gut feel on that one. Karen Reed. You know who's covering Karen Reed? Brandy Churchwell is covering Karen Reed, and she's actually got a podcast on that. She's doing a great job. She's digging into this one very, very well. And I think there's no way I could come close to covering it the way that she does. Brandy Churchwell is a good friend of the channel as well. Another YouTuber. If you need her link, you could just type !Brandy in chat. That's BRANDI, and that will get you over to her channel. Okay, I think that's it. Bon appetit. That's it. That's our signal. It's time to go to lunch. If you like what you heard today, if you like this type of coverage, first of all, thank you. I appreciate you being here. It's no small thing for you to spend your time with me, and I do appreciate that. Second, I would ask that you do click the subscribe button and maybe even ring the bell so you get notified every time we go live. We do this every day, all day. This is my only job. I quit my IT job with the federal government, and this is what I do. And so I love it. I've been doing this for almost exactly a year now, and it has been wonderful. The best job in the entire world since the day I started. And mostly it's because of the people I get to hang out with, which is with you. So thank you very much. If you do like that, do click the subscribe button, ring the bell. We'd love to see you back after lunch because it's going to get spicy with the directed verdict discussion that's going to come on with the judge. Hopefully he answers all those outstanding questions. Obviously, Mr. Shapiro stepped in it earlier today and managed to wade through and come out not smelling like what he stepped in. So, crazy day, as it every single day seems to be in this trial. But thank you very much. We're going to go to lunch. We're going to be back in 1 hour. Oh wait, they're going to be back. We're going to be back in 45 minutes. I'm sorry, I ate up your lunchtime. I apologize. We'll be back at 1 o'clock. The first person in chat, as always, we gift them the internet. It's just a little thing we're able to do. So if you'd like to be that person, make sure you have the bell rung and just be the first person to talk in chat once the placeholder's there, and you'll win. That being said, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in 45 minutes. It'll be 1 o'clock where we catch part 2 of today's proceedings in the Take Care of Maya trial. All right, thank you very much. Appreciate the mods. I could not do this without you. Mods, you've been working overtime. It's busy in chat, but they are so amazing. I could not do this without them. Thank you so much, mods. Giuseppe, thank you for the super chat. I should know how to say that, but I don't. But I apologize. Giuseppe, that's my best effort. All right, that's it. Go have some lunch. We'll see you back in a little bit. Bye-bye.